Good morning, everyone. First of all, wish you a happy Shivaratri to all of you, and also happy Women's Day as well. Women. So, Women's Day is to be. When is Men's Day? No. When is Men's Day? International Men's Day. ఉందా ఒకటి? Is there? నవంబర్ మార్చి 8 ఒకటే గుర్తుపెట్టుకుంటారా? Won't remember International Men's Day? US. So we were studying fundamental rights. In that we finished right to equality. We were in right to freedom. In that we have studied Article 19. Article 19, all the freedoms relating to freedom of speech and expression, freedom of assembly, freedom of associations, unions, freedom to move freely throughout the territory, freedom to reside, settle, and also freedom of occupation, profession, and business. So all those 6 freedoms of 19 we have studied, and then we have studied Article 20. Article 20, what are the 3 principles we follow in Article 20? No ex post facto law, no double jeopardy, no self-incrimination. So these 3 principles, most importantly, you have to write those principles. The term also becomes important. Anything regarding Article 20 is used, that term also becomes, you may write in your, if it is main examination, you are writing in your own words also, but better mention the term. Self-incrimination ane term badali. Double jeopardy. Okay. You may write double punishment also, but it is better to use the word jeopardy because of the principle kabatti. And also no ex post facto law. Okay. Then let us see Article 21. Article 21 of the Constitution. Article 21 is considered a very important amongst fundamental rights. Of course, all fundamental rights are important, nothing like, but this is concerning your very life and freedom. It's also with life, it also with freedom. That's why we are giving so much importance to Article 21. This speaks about, though it mostly tells about your life and personal liberty. In short, we say it is a fundamental right to life and personal liberty. But we have to study it in detail. There is so much of meaning in Article 21. Many cases are also filed regarding Article 21. There are so many case laws regarding Article 21 because it is concerning your liberty, your freedom, and also your life as well. Your life may be in danger, may be put in danger. Sometimes state only may take away your life. Police may in fact put your life in danger. So all these issues are there. So state cannot take a life as it wants. Starting with your Magna Carta in the UK, they limited the powers of king, saying that, hey king, you cannot kill whenever you want, however you want. It cannot be so arbitrary that you will take away life of a person. There should be a law. You remember the barons, they held the king for ransom. Oka rakanga kidnap chesesaru king ni. Okay, they have king, you write a law. Only as per that law only you can kill us. Otherwise you can't kill as you wish. So that was Magna Carta. In a way, barons were protecting their rights, their right to life kind of rights in England. So as things went by, UK constitution evolved. In India, first constitution came, then only we say rights came. In the constitution, there are rights. So in our constitution, it is important that we say that there is a right to life. But when you say there is a right to life, Article 21 says there is a right to life. Does it mean that under no circumstances your life can be taken? Are we saying that? Ante manam antunnama, you can't take away life of anybody. Can state cannot take life of anybody? Is that the meaning? No. There can be situations where the state can take a life of a person. How? By giving death sentence. By giving death sentence, we have taken away life of recent, if you see, Afzal Guru was hanged to death. Ajmal Kasab was hanged to death. As recently in 2020, Nirbhaya gang rape incident, the 4 accused people, those people were hanged to death in 2020, March 20. TR Jailo, we have hanged them to death. Who hanged them? State. So state can take life of a person. It is not as if state cannot take a life of atla kaadu. State can take, but only if there is a procedure established by law. There should be a law, there should be a procedure. So, which means, can you take away, Article 21 is saying there is a right to life, right to liberty. You have a right to life, right to liberty, but if there is a law, and the law gives a procedure, by that procedure, you can take away life of a person. Life of a person or liberty of a person. Liberty తీయడం అంటే అరెస్ట్ చేయడం. You are being detained, you are being arrested, you are being confined, you are put in jail, imprisoned. So yes, your liberty also can be taken away. You will be put in jail ante నీ liberty లేదు. You don't have liberty to go out of the jail. So can you do away? Yes, but there should be a law and there should be a procedure established by law. This procedure should be established by law. Otherwise, you can't take away life of a person, liberty of a person. So a police, because he has a gun, can he randomly kill anyone? Why not? Because there is Article 21. He has a gun. It is a weapon which can cause a damage to a life. Why cannot he not be trigger happy? Trigger happy ante trigger ni edo Diwali gun laga trigger anukodu kada. All how in movies they are showing. Okay, in movie, hero is IPS officer, jumps from buildings, this, and he keeps shooting. Atla real life lo, very rarely those things happen. Tomorrow, if you are becoming IPS officers, most of you, except in training, you may not even shoot once also. Except in training, there may be a chance you may not even shoot once in your life also. Training lo, you will training practice kabatti, you will have to shoot. Otherwise, chances are there you may not even shoot once in your life. Blessed are those people, we say, because avasram padledu. No need of such a heroics, no, not necessary also. You have your subordinates who will do that thing. When you become IAS, IPS officer, you don't need to do hangama. You are more like a manager in chief laga. Okay, you are a personal manager, personal management నేర్చుకుంటావు now. Like there are, you have, and once you are like, let us say SP of a district, you have ASPs, you have DSPs, under them there are inspectors are there. Okay, under inspectors you have all these sub inspectors are there, the CI, SI are there. Okay, and then you have the constabulary. Those people, they are trained to use weapons and all. You will also be trained, but just because in movies how they are showing IPS officer అంటే ఇంకా గన్ తీసి ఉరుకుతాడు, జంప్ చేసి, ఆల్ ది సింగం టైప్. ఓకే, సార్ జస్ట్ మూవీస్. అట్లాంటి మూవీస్ చూస్తే ట్రైనీ హూ వాంట్ టు బికమ్ IPS ఆఫీసర్స్ చెడిపోతారమ్మా. ఓకే, బికాస్ యూ కాంట్ షూట్ ఎట్ ర్యాండమ్ అండ్ విల్. యు ఆర్ డెఫినెట్లీ అకౌంటెడ్ ఫర్ వై యూ హ్యావ్ షాట్, అండర్ వాట్ సర్కమ్స్టాన్సెస్ యూ హ్యావ్ షాట్, వాట్ వాజ్ ద రీజన్ టు ఓపెన్ ద ఫైర్ అని అంటాం, ఓపెనింగ్ ద ఫైర్ అని అంటాం. Why you had to open the fire? Because you're not supposed to open the fire as a normality. Only circumstances untene you have to open the fire. So you cannot become trigger happy. Trigger undi dani nokkuta ane undadu. Generally safety lock pettuntadi eppudu. Always for your revolvers, arms and all, there is a safety lock. Removal of safety lock itself means you are getting ready to fire. You can't become trigger happy like that and shoot as you want and all. You will not be allowed. So here you have to, if at all you have to shoot also, if you are shooting someone also, taking away life, that is equivalent to taking away life. If you are taking away life, how you can take away? There should be a law and a procedure established by law. I hope you are understanding. There should be a law and procedure established by law. Then only you can take away life. Now, death sentence has been given to someone. Somebody got death sentence. So, he is being taken to the gallows. He is being taken to the gallows. There will be a person who will put that gallows, and then he will be put on a platform, and then there will be a lever upon nowadays the electronic వచ్చేసింది ఎందుకు అంత కష్టం. Okay, so electronic lever వచ్చేసిందంట. So when the button is pressed and all, the platform is removed and the person hangs to death. The person will hang till death. That is there given in your criminal procedure code and all. It is clearly given that this person ila hang cheyali to death and all. This is the procedure you must follow. And when you can give death sentence, that is all given in IPC. And IPC, CRPC, these are talking about death sentence and all. Hanged by the neck till death. Eppudu ivali, eval confirm cheyali. All those are given in a law. In IPC, CRPC, that is our law is there. In that law, you are saying there is a procedure when only you can take death sentence can be given and life can be taken. Except like that, you can't take away life of a person. State means state. Human beings are killing each other. Murder case lo, homicide case lo hotai. But state can it take away life of person only if there is a procedure established by law. And what about liberty? You can take away liberty. Liberty means arresting, detaining, putting in confinement, jail for 2 years. You are getting imprisonment for 10 years, 5 years, 7 years, 6 months, 2 months, 3 days, 5 days, whatever. Your liberty is being taken away. That also you can do only if there is a procedure established by law. That is what Article 21 says. I hope you are understanding. Article 21. Now let us read the text of Article 21. No person. Person means citizen, non-citizen. Even foreigner also we can't take away life as we want. No person shall be deprived of his life or personal liberty except according to a procedure established by law. Procedure established by law. Only like that you have to take away life of a person. What? Or liberty of a person. Means jailing them, confining them in a prison. How you can do? Only if there is a procedure established by law. So this is available to citizens as well as non-citizens also, foreigners also. Now, when you tell this, what is happening when you tell procedure established by law? Means if there is a law and if the law is telling certain procedure, like this you can take away life of a person, or for this offenses, ilanti crime cheste you can take away life of a person. So if you tell like that, you can take away life of a person, you can take away liberty of a person. Am I correct? Yes. In a way, it is protecting you. It is protecting all the people from executives' arbitrary events of detention or arbitrary events of killing. Ante executive cannot commit excesses. Executive cannot take life or a liberty except if there is a law. Isn't it? Executive and think of police. Police cannot kill randomly anyone as they wish. They cannot kill. Police cannot arrest as their wish, because you will ask, hey, why are you arresting me? Under which what law? You are arresting me and you are going to put me in prison. Why are you imprisoning me? Why are you putting me in custody? There should be a reason, right? Without a law, you cannot take away liberty or a life. So in a way, executive is limited here, isn't it? Executive's powers are limited. The executive can be prime minister, chief minister, it can be any minister, any of the bureaucracy under them, public servants, civil servants, any of them, they can't take away life or liberty of person. దానికి ఏముండాలి? Law undali, law cheppina procedure undali. There should be law and a procedure. So it is protecting you against what? Executive's arbitrary action. Isn't it? It is protecting you against executive's arbitrary action. So what happened was, there was a communist leader by name A.K. Gopalan. ఈ A.K. Gopalan అనే అతన్ని what they have done is, in 1950, from 1947 onwards, this person was under detention. He was under arrest. This communist leader. He was, in fact, doing things against the state and all like that. He was speaking out and in a very rebellious tone and all. He was arrested. He was arrested under a law. There is a law called as Preventive Detention Act. So, in Preventive Detention Act law, this person got arrested. As per this, ఇది ఒక law కదా, ఒక act అంటే ఏంటి? Act comes under law? Yes. ఈ lawలో there is a particular section. Just I am giving you more explanation. No need to write in the examination. Just for your understanding, I am telling you. In this law, there is something called as section 14, which tells that ఈ యాక్ట్ కింద అయితే no need to tell reason also you can arrest అనే ఉంది అందులో. Under Preventive Detention Act, no need to even disclose the reasons why you are arresting also. Like that, the reasons also need not be disclosed. Like that, section 14 అని అందులో ఉంటుంది, Preventive Detention Act లో ఉంది. So this person, A.K. Gopalan, what he did was, since he was in prison, he challenged it. He challenged and went to all the way to Supreme Court, saying that it is violating my Article 14. Sorry, my Article 21. My liberty, because life and liberty, right? My liberty they have taken away arbitrarily. నన్ను అరెస్ట్ చేశారు for no reason, without any proper reason. So they have arrested. అని this A.K. Gopalan had gone to Supreme Court. So Supreme Court in 1950, at that time, just that time, Constitution came into force. When Constitution came into force, this fellow challenged. So in Supreme Court in 1950, it looked at Article 21. The text of Article 21 was seen. What is the text saying? Nobody will be deprived of life or personal liberty except procedure established by law. And a law unde you can deprive, isn't it? So what did the Supreme Court say is, see, there is a law. There is a law. As per that procedure only, they have arrested you and you are detained. You are put in prison. So police did not do anything wrong. They acted on procedure established by law. Law undi kabatti they have arrested. They have detained you. They have put you in prison. So it is nothing wrong. They didn't do anything wrong. Whatever they have done is right only. But A.K. Gopalan was saying, sir, aa law ne tappu sir ani antunnadu. A.K. Gopalan is telling, okay, there is a procedure. As per the law, there is a procedure. Police did not do anything wrong. But the law itself is, ide tappundi, ikkade tappundi, law lone there is a problem, he is telling. In the law only, how can you arrest like that without any reason? Without any reason, you are arresting, that is not proper. This is what A.K. Gopalan is challenging. But Supreme Court at that time, what it saw was, it gave a narrow interpretation of Article 21. It gave a literal interpretation. 1950, just now Constitution came. So Supreme Court said, మాకైతే తెలియదు అందులో ఏముంది Article 21, what it is there? It is saying, if there is a procedure established by law, your liberty can be taken away. So ఒక law చేసింది Parliament. There is a Preventive Detention Act. In that, there is a section 14. As per that, without reason also, you can be arrested. So you got arrested. So your protection under Article 21 is only against executive action only. Executive ఏదైనా action చేస్తే దాని నుంచి you have protection, but not against legislative action. Law who makes some? Legislature. ఈ law లోనే some mistake is there that you are not protected. But executive did something, there you are protected. Your life and liberty is protected against executive. They should not do on their own. They should follow the procedure established by law. I hope you are understanding this. What did the Supreme Court tell in A.K. Gopalan case? In A.K. Gopalan case, Supreme Court is telling you have in 21, if you read, if there is a procedure established by law, you can be arrested. You can be detained, put in jail, or even death sentence also can be given to you. But if there is a law, if in law only there is a problem, if a legislative action something is there, that protection will not be given in Article 21. Because nothing is mentioned in Article 21 regarding arbitrary legislative action. It is only saying procedure established by law. The law unte okay. But this creates problems. But this interpretation will create problems. Why? Because tomorrow, if a law is made saying that law is there, procedure is there, then okay, right? You are saying okay. Then let us say if tomorrow Parliament makes a law saying that if you do not clear preliminary in the first attempt, 1 year jail. Will that be okay? But procedure established by law. Law just in the Parliament. If you don't clear prelims in one exam, in one attempt, first attempt, if you don't clear prelims, then 1 year jail you have to sit. Why is it wrong? You're taking away personal liberty by a law kada. Ante law unte thiyochu kada. Only executive should not do, but law can take. So it creates a problem because what are you saying is that such law, alanti law cheste, do you think that law is reasonable? Do you think that law is fair? You will say it is unfair. And prelims clear the jail estava. You are not. Isn't it too much? That itself is a punishment. Not clearing itself after 1 year of effort. If you don't, that itself is a punishment. A punishment kaakunda, you will give more punishment. What is this? It is unfair law. What is this arbitrariness? Parliament ingem panleda meeku? You will say, right? Vere panle mileva inga maa meeda padda. That's what you will say, right? It is what you are feeling. You are feeling that some laws may be unreasonable, unfair, unjust. Unjust ante justice cheyatledu. Injustice will happen. Some laws may be unfair, unreasonable, unjust. I'm coming to that. I'm telling you in a sequence. But at that time, Supreme Court did not think that much because just now Constitution came into force. Supreme Court said we will do literal interpretation of whatever is there in the Constitution, we will do. So in Gopalan case, he said, Gopalan, you won't get any relief. Okay, because you are Gopalan, there is an act. Okay, ఆ యాక్ట్ లో అయితే ఉందిరా బాబు నిన్ను అరెస్ట్ చేసుకోవచ్చని, ఎందుకంటే without reason also. See, what can we do? Your protection is only against executive action. Executive can't do anything arbitrarily. Police can't do arbitrarily. But law నుంచి అయితే నీకు ప్రొటెక్షన్ లేదు. అది పార్లమెంట్ ఇష్టం. That is, parliament can do something. But giving this, but what if parliament does something arbitrary? Parliament does something unreasonable, unfair or unjust. So that is the reason this interpretation got corrected in Menaka Gandhi case. In Menaka Gandhi case, so you know who is Menaka Gandhi? Heard of Menaka Gandhi? Heard of Sonia Gandhi? Sonia Gandhi Todikodalu. Okay. So Indira Gandhi, 2 sons. You know who are they? Do you know Indira Gandhi had 2 sons? Who are they? You know? Rajiv Gandhi, Sanjay Gandhi. Sanjay Gandhi's widow. Sanjay Gandhi passed away. So his widow, his wife, wife was Menaka Gandhi. Okay, so she's still there. She was an MP, and recently also she's a animal. She cares for the animals also. She's an animal activist also, and she was a former minister also. But she's in the BJP again. So um, she was in nice terms for Indira Gandhi for a lot of time. So, but after the death of her son and all that, somehow she was there. Inka typical Sas Bahu, Atta Kodala serials and all that, what we don't know. So somehow Indira Gandhi said, no need to be in the house and all. So Menaka Gandhi came out. Menaka Gandhi came out, and she's from that time, she and her son and all, they are also into polling. Her son Varun Gandhi is also in BJP and all, they were there. Anyways, that is Menaka Gandhi's line. So this was the time when Menaka Gandhi was in Congress. She didn't go away. She was with Indira Gandhi at that time. Indira Gandhi, we'll see later, from 1975 to 77, Indira Gandhi imposed emergency. Indira Gandhi imposed emergency in the country. And many people say this is an internal emergency, not required, but aina pettaru ani. This emergency was not required, and still it was put. That's what many people allege, that excesses were done during emergency. Chala ati chesaru emergency lo. That's why in 77 elections, Indira Gandhi lost. Congress party lost. Okay, and Janata government came to power. So there is a. So Janata party came to power at that time, with Morarji Desai and all as a prime minister. So when opposition party, Janata party and all, it came to power at that time. Morarji Desai as the prime minister. At that time, the then home minister was Babu Jagjivan Ram. Heard of Babu Jagjivan Ram? Babu Jagjivan Ram was a home minister in Janata party government. Now, Congress people are in the opposition. Congress are in opposition. That means Indira Gandhi. Okay, and Menaka Gandhi was at that time with Indira Gandhi only. She was working with closely with Indira Gandhi. So Janata party, the home minister who was there, his son was a kind of a playboy kind of person. Babu Jagjivan Ram's son was a playboy kind of a minister, typical minister son type of person. So when he was in the privacy with a college girl. He was in the privacy with a college girl, and at that time, in that private moments, Menaka Gandhi was running one magazine. Menaka Gandhi used to run a magazine. That magazine, they did a sting operation, like secret cameras and all they put. No, so like that they put these secret cameras in Babu Jagjivan Ram's son, what he's doing and all, this fellow. And minister like that they secretly they followed him, and they put some secret cameras they put, and they captured this fellow in a private moment with a college girl and all. They have taken, and they published those photos also in the magazine. Go chudandi what home minister's son is doing, all this and all like that. They have published. So Menaka Gandhi's news, she was running a magazine. A magazine he panchesindi. Obviously home minister got angry. Against my son you are putting all that, and society how they will treat immediately. See, home minister's son is doing like this with college girls and all that. Immediately there was a backlash against the government. So government became very angry. Janata party government became very angry against Menaka Gandhi for doing this. But so what they did was, what Menaka Gandhi per se they should have put under certain things, but they have put so many sections against her. And what they did was, they wanted to send her to jail somehow and all that. First, they felt that she may escape. They felt that we should not let her escape from the country also. And immediately they have seized her passport. Her passport was impounded. The passport తీసేసుకున్నారు, so that she can't go out of the country. Menaka Gandhi got angry. Hey, what did I do? And you're taking my passport? Don't I have a right to do? I don't have fundamental rights to travel abroad and come back? If I want, I should be able to go abroad also. How can you take away my passport? Is it not violating my fundamental right? Don't I have personal liberty? So like that, the case went all the way up to Supreme Court. She filed a writ petition that my personal liberty has been taken away. My personal liberty has been taken away. And she went to Supreme Court for a writ petition. Fundamental rights violation, you can go to Supreme Court also? Yes. So she went to Supreme Court saying that my Article 21 has been violated. My personal liberty has been violated. Like that, Menaka Gandhi went to Supreme Court. Obviously, citing A.K. Gopalan, government, it argued in the Supreme Court saying that the Janata Party government, will argue yes, ended Supreme Court. There is a law under which we can take away passports. We can impound the passport. Yes, we can arrest as we want and all. They cited A.K. Gopalan case. See, Gopalan case, if there is a law, you can do. Isn't it? If there is a law, executive can do anything. It can take away liberty. It can take away life. So there is a law. As per that law only, we have taken her passport. Tomorrow, as per that law only, we may arrest her. Like that, they cited A.K. Gopalan case. But Menaka Gandhi side, they argued further, saying that, what if law is only unreasonable? What if this law that you made regarding impounding of passports, if that law is unreasonable, what if it is unfair? What if it is unjust? So, which means that legislative it can take away life, liberty. Tomorrow, can you make a law, just say, if people come out of 10 o'clock out of the houses, they will be arrested for 1 year. Like that, if the law is made also, you will be taken away your liberty. Then what is the use of your fundamental rights? Oka hand to ichesi inko hand to tiseskunnattu kada. It is as if you are giving with one hand. You are saying you have a right, you have freedoms. Article 19 is giving you freedoms. You are saying you can, freedom of speech is there, freedom of expression is there, freedom to move is there. Anni cheppi malli if a law is there, we will take it back under etla. So that's why that was challenged in Menaka Gandhi case. Then what did Supreme Court say is, Supreme Court said that fundamental rights you have to study along with other fundamental rights. If there is one right, one article, you have to study along with the other rights in the fundamental rights chapter. So when you read only Article 21, it is looking as if a procedure established by law is there, you can take away fundamental rights. But when you study it along with Article 14 and Article 19, when you study, it is forming a golden triangle, it said. Only 21, if you read like that, it looks like a procedure established by law, you can take a life liberty. But if you read along with 14, what is 14? Right to equality, equality before law, equal protection of laws. What it does? It prevents you from arbitrariness. Remember, arbitrary cheyakodadu ani Article 14 antunnam. Gurtunda? Do you remember? Then what is Article 19 saying? Freedoms, all the freedoms that are there, that are saying, except reasonable restrictions, you should not take away that freedom we are saying in Article 19. In 19.2, there are reasonable restrictions. Otherwise, you should not take, we are saying. When you read along with 14 and 19 and 21, it is forming a golden triangle. And with this, you are not only getting procedure established by law, but there is something called as due process of law also. So in Menaka Gandhi case, the doctrine of due process of law came into existence. What is this due process of law? Means even legislature, when you make a law also, that law should be fair. It should be reasonable. It should be just. If you make a law which takes away life, which takes away liberty, it should satisfy these three. Tomorrow, Parliament is making any law. Why Parliament cannot make a law saying that, prelims, if you don't qualify in first attempt, you will be in jail. Why Parliament? Because it will be unfair. It will be unreasonable. It will be unjust, isn't it? Nonsense, arbitrary law it will become. Because no reason, it's not fair, it is not just. So Parliament, that's why it cannot make a law like that. So it said that the due process of law vastundi. When does it come? When you read 21 along with 14 and 19. Only 21 if you study, you will find only procedure established by law. But if you go deeper and understand that you read along with 14 and 19, then there is something called as due process of law. So because of due process of law, what it means? The law that is made. So here we are saying procedure established by law. Okay. But the law that is there also, this law also, this law which takes away life or liberty, that should satisfy fairness, reasonableness, and just. So this is called as due process of law. And it said, and this is a concept borrowed from American Constitution. So while Supreme Court giving this judgment in Menaka Gandhi case, it had studied American Constitution. Avunu kada Gopalan case we have given judgment like that, but it is not correct, right? What if the law only is unjust and unfair? That's why that from where it is in American Constitution they have seen, acha, there is something called due process. Means the law also should be fair, reasonable, and just. If you want to take away life, liberty. So that's why if a theft is committed, you won't give him death sentence. Why can't you give? Can Parliament make tomorrow law saying theft? Everybody who commits theft and all, they will get a death sentence. That is not reasonable punishment. That is not a reasonable punishment. That is not justice. Theft ke urestara? Should not be like that. Only rarest of rare cases only we are giving death sentence. So that is why the law you take away life, the law taking liberty, it should satisfy these three, which means due process of law. So now, right now, Article 21 has both procedure established by law as well as due process of law. Not in the text. So text lo ekkada sir nenu 21 open cheste kanpinchatledu ante adi kanpichadu due process of law. There are no words mentioned in the constitution. Due process of law bolke nahi hai. Text pe nahi hai. How you will get? When you read along with 14 and 19. So we are saying it is like a golden triangle, we are saying. A golden triangle, when you read along with 19 and 14, you are getting the due process of law. It was introduced in Menaka Gandhi case. If at all anything Article 21, you don't write all Babu Jagjeevan Ram son and all. That I told you. What is Menaka Gandhi case? I told you. They won't ask you in the exam. Emaindi ani em adgaru. Nor in the books it is mentioned. Just and enti ane doubt also. That's why a little more information I gave you. Only you have to say is in Menaka Gandhi case, we brought into the existence, the court had introduced American expression due process of law also. That right to life of a person and personal liberty of a person can, you are saying that it can be deprived only if the law is reasonable, fair, and just. If you want to take away life of a person, it should be reasonable. No, it should be just. It should be fair. The three important elements. So today, is there any law which takes away life of a person, liberty of a person? Yes. They are all fair, reasonable, just. In IPC, we give death sentences, we give for what? For various things, murder, okay, rape and murder. In such instances, we give waging war against India, kidnapping for murder. Also, Atlantic offenses ki there are other offenses also where you give death sentence also. You give death sentences istar, but they are reasonable. You committed murder, you have taken away life of a person. You are waging war against India with weapons and all. You are waging war against India. So Ajmal Kasab, what Ajmal Kasab did was, the 26/11 attacks. They came, they are terrorists. They entered India, shot at will as they wanted in a CST and Taj, Mumbai CST station, as well as in Taj Hotel and all that. They have created massacre. They killed foreign terrorists, raped, murdered, yanni jesar. So it is a just, such people who are waging war against India or murdering, itlanti yanni వాళ్ళకి just punishment adu. Whenever we give, for not every murder we won't give you death sentence. Most of the times it is life imprisonment. Most of the times. Generally, rarest of rare lo istam. Rarest of rare. Rarest of rare cases, we give death sentence. Liberty, taking away liberty, many laws are there. IPC, many sections are there where it will give punishment 2 years, 6 months, 3 years, 5 years, 7 years, 10 years, 14 years, or life imprisonment. complete life imprisonment kuda iyochu. And many people have a wrong notion of life imprisonment. Life imprisonment means for life, not 14 years. Life imprisonment means for the remainder of your life. Life mottam ani meaning life imprisonment means. It doesn't mean 14 years. Why people think 14 years is until 14 years you can't have remission also. And a chance of coming out also is no chance of and sometimes some kind of pardons are given. Okay. Sat pravartana, good conduct. Okay, he మారిపోయాడు మనిషి. He has transformed, reformed. Okay. At that time he did, but now at that time he did murder or he did, but now he has become a nice person. He realized his mistake. 14 years he may have changed. So that's why after 14 years there may be chance of remission. Up to 14 years remission chance kuda undadu, life imprisonment. That's why we say 14 years, but it doesn't mean 14 years. If you don't get remission, entire life, remainder of your life. And in most rape related offenses, 376 related offenses andam IPC 376. So these are for lifetime. Life imprisonment madte inga mottham inga jail lone undali. So that type of offenses we are taking away liberty. Yes, we are taking away liberty, but the law is reasonable, the law is fair, the law is just. That's why we are taking. So here by bringing in due process of law, now we have both, right? Now we have procedure established by law and also you have due process of law. The earlier one protected you only against executive action, right? Executive arbitrary చేయకుండా మాత్రమే ఆపింది అది. Only that was protection. But by bringing in due process after Menaka Gandhi case, even legislative arbitrariness also you are protected from. Are you getting an idea? So Parliament also cannot make as they want laws to take away your life or liberty. So both you are being protected now after bringing due process of law. Did you understand what is procedure established by law and due process of law? Will you be able to differentiate both of them? Okay. So AK Gopalan case kasta narrow ga chusindi Supreme Court at that time. Only what is their due procedure established by law is there, that much only understand. But in Menaka Gandhi case, it in fact it overturned the AK Gopalan judgment. Ledu appudu tappu cheppam. So Supreme Court what it can do is it can revise its own judgment, it can review its own judgment, it can change it also, it can overturn that judgment also. So that happened even in the case of, you are seeing even preamble case also you have seen, right? So you have seen earlier Berubari Union case, it said that preamble is not part of constitution, but in case one Ananda Bharti said is part of the constitution. So it can overturn the earlier judgment and it can give a new interpretation. So here also in Menaka Gandhi case, it gave a interpretation saying that 21 अकेला नहीं देखना है 14 और 19 के साथ जब मिला के देखते हो तब golden triangle आएगा, and that gives you due process of law as which is there in the American Constitution. So the words due process are not there in our Constitution, but interpretation we have to do like that, Supreme Court said. How we have to interpret Constitution also, Supreme Court is the final sayer. Supreme Court has the final say on how you have to interpret Constitution. And the Constitution किस नजरिए से देखना होगा, how to interpret it, should you interpret along with the other articles, what is the meaning of the word, these all Supreme Court has the final say. Okay, so that's how you are now even being protected against arbitrary legislative action also. Okay, so also now coming to the meaning of, now if you understood what is procedure established by law, due process of law. Now let us come and understand, the moment you are saying life, the moment you are saying personal liberty, what is the meaning of life? Life only means breathing, mere survival. Animal is also surviving. Some animal is there, it is also surviving. Outside some dog is there, pig is there, it is also breathing. That is life. You are also breathing, it is also life. Only like that you will see. Or we should see life in its entirety, we have to see. Life means it includes all the facets which makes a life a dignified life. A life with dignity. Dignity is important, mentioned in the preamble also. So life means all the aspects which makes a person's life dignified, a person's life wholesome, holistic. Like that we have to treat life. So the meaning of life, Supreme Court said that. Supreme Court said don't treat life means only animal survival. Like how animal survives, you are also surviving. You have a life breathing. Ho gaya, it is enough life. No. Life means a dignified life, it said. So life, it doesn't just mean an animal existence, means how you are just existing or breathing, but it includes right to live with human dignity, life with the dignity, and all those aspects which will make your life meaningful, complete, and worth living. That much deeper meaning is there just by mentioning life. And liberty also, it has given a very deeper meaning. We have studied liberty in preamble, concept of positive liberty, all the aspects which help you to grow, right, to develop and all that. It may include education also, right? Education, freedom, it may include privacy also. So all those aspects which are important for your liberty. So Supreme Court, what it has done is, it has given a very wide meaning, very, very wide meaning, wide interpretation it gave to life and to liberty. Very wide, not just survival. Not just survival, but a life with a dignity, life which is meaningful, life which is worth living. So that kind of, it had brought with various cases. Various cases were filed in the Supreme Court. Supreme Court said that this right also comes under right to life. For example, right to clean environment, right to pollution-free air. So there were cases filed against polluting factories inside the towns and inside the cities. Today, if you see, you won't have polluting factories inside the city. They are outside the cities. They are outside the towns. Because earlier cases were filed, how can a polluting factory be inside the town, inside the city? Because it gives so much of polluted toxic gases are there. If I breathe these toxic gases, I may die. So indirectly my right to life is gone, right? So it is the duty of the government to keep polluting industries away from the towns, away from the cities. So right to clean environment, right to pollution-free environment is also coming under right to life. Okay, like that, so many rights are brought under right to life. So many rights are brought under right to liberty. Other rights are indirectly brought under right to life, indirectly brought under right to liberty. So, in various cases of Supreme Court, it said that following rights are also part of Article 21. These all rights are also under Article 21. So let us quickly see what all come under this. Right to live with human dignity. To live with the dignity is also a right to life. Because life means life with the dignity, it said. Right to decent environment, pollution-free water, pollution-free air, protection against hazardous industries also comes under Article 21. Right to livelihood. Livelihood means earning one's livelihood. Jeevanadaram edo okati. Okay, maybe, some kind of earning you want to make. So that also comes under right to life. Because if you can't earn something, and how will you live? At least you won't be living with the dignity. You will be begging. That is not a dignified life. So that's why we are saying that right to livelihood is also coming under right to life under Article 21. Right to this livelihood also. Right to privacy. There is a important case. We'll discuss that. Right to shelter. So right to have some kind of shelter is also your right to life. It comes under, because you don't have shelter, shelterless people roaming on the roads and all that. So it is not a right to, you're not living with the dignity then. So that's why if a shelterless persons, if they ask the government, they have to be provided shelter. Compulsory, because it's a fundamental right. So in fact, for most shelterless people, government arranges shelter homes, but they are in the outskirts of city. Sometimes they take these people and they put them in the shelter homes. That is another problem. Even if you take and keep them also, somehow ikkadem baaledu. Are we are putting everything, no, daily morning idli vada and all, we are putting nice breakfast and all, stay here also ఏం లేదు నేను అక్కడ అడుక్కుంటేనే బాగుందని. Some people come like that. Unfortunate. Some people, they are mentally disturbed and all also, they come away. They run and they come away. So that's why you will see in batches, suddenly, no, in 1 month you will see all the beggars disappeared. Another month they will again reappear. Why? Because sometimes the government, other officials and all will తీసుకెళ్ళి మళ్ళీ shelter homes లో వేస్తారు. Sometimes they again come back. A new batch comes. Next batch. So with all respect, due respect and all, we can't, so it is their condition. Some of them are suffering from mental health conditions. Some of them are abandoned by their children. Some of them, somehow, in their life, they have lost interest, though they are not mentally that much challenged. But, they have taken one perspective that, this life is better. So for various purposes, they take to begging, and shelterless people are also there. The unfortunate reality. Most of the times, if they ask that it is my fundamental right to shelter, government should provide at least some shelter home. Means not a permanent house. Temporarily, they can live in that shelter home. Like that, at least government should provide that, because it is a fundamental right. Right to health. A right to health and health services is also fundamental right. That's why you have government hospitals. That's why you have government hospitals. Government completely cannot privatize health at any moment, because health is a fundamental right. You will, and most people have a wrong conception that government hospitals are only for poor people. I also can go to walk to any time government hospital. Any person can go to government hospital and avail free health services. Anybody can go into government hospital. Free health services they can obtain to a government hospital. Okay, so right to health, fundamental rights. In one case, it also said right to free education up to 14 years of age also is like life means what? All those aspects which life with the dignity. So life with the dignity and all, which means you need education also. Without education, what is, you won't have a life with the dignity without education. That's why up to 14 years also, you should get education. That is also a fundamental right. Later, this one, in a Supreme Court, in a case, it told that. Later, this was made as a special fundamental right, 21A. Later, after Supreme Court said this, 86th Constitutional Amendment Act was made, 2002, making this into another fundamental right, 21A. It's a separate fundamental right now we have under 21A. 86th Constitutional Amendment, 2002, made it into a, Parliament had passed one constitutional amendment and made this into a fundamental right. 6 to 14 years, free and compulsory education. Right to free legal aid. Now, so many things, if you remember, fundamental rights are justiciable. Justiciable means enforceable in the courts. These rights are, and you can go to the Supreme Court also, he said. Or you can go to the High Court also, that is another thing. You can go to the Supreme Court, highest court in the country also you can go, saying, restore my fundamental rights, give back my fundamental right, give me remedies. Like that you can go. But let us say, after listening to the class, let us say you went to the Supreme Court, your fundamental right got violated, some police illegally arrestation. You went to Supreme Court and gates, restore my fundamental right, watchman bite go. Or if you went there and nobody is, you went to an advocate and all, he said, what happened and all, saying, my fundamental right, police, Telangana, Hyderabad police, they violated my fundamental right. Acha, okay. And he said that, okay, so file a writ petition. So, sir, cheppandi maaku, Article 32 untadi. So, you can go to the Supreme Court also, it seems, means, that's why I came, means, okay, good. Okay, Article 32 bane undi, you pay 32,000, you will say. Are, aden, sir, it cheppaledu naaku. I didn't tell money means, but then how I should survive? Advocate, no, I have to go and argue my time, I have to draft your petition and all. How I will, sir, na దగ్గర డబ్బులు లేవు, no, money is not there. I only heard fundamental right and I came, means, మరి ఏం చేద్దామంటే, okay, you go, there is a cell called as Legal Services Authority అని ఉంటుంది. You will have in every court, you will have legal services. Legal Service Authority, Legal Services Cell, ఇవి ఉంటాయి. There, free legal aid will be given to you. There will be advocates who will be in charge. They will give you free legal aid. free services provided you are either from scheduled caste, scheduled tribes, backward classes, transgender, or you have or income certificate that you cannot afford these services. Ivanni unte, then if you have money and you are saying free, no. So if you come under those conditions, if you qualify under those conditions, then you can avail free legal aid. So this came up to Supreme Court. So in a case called as Husainara Khatun ani oka case untundi. Husainara Khatun versus State of Bihar. So ee case lo Supreme Court realized that adda baundandi constitution, fundamental rights violation aithe coming to Supreme Court, High Court, but who are coming? Only rich people are coming. People who can afford only are coming. What about poor people who cannot afford, who don't know asala fundamental right undani kuda teliyadu chaala mandiki. They don't even know that I have this fundamental right. ఆ పోలీస్ అంటే కానిస్టేబుల్ అని అమ్మో కానిస్టేబుల్ కొడతాడు, ఎందుకు కొడతాడని అమ్మో తెలియదు, దూరంగా ఉందాం. సో ఇన్ ఎ సిటీ లైక్ హైదరాబాద్, కానిస్టేబుల్ మే నాట్ హ్యావ్ సో మచ్ ఆఫ్ పవర్, బట్ ఇఫ్ యూ గో టు ఎ విలేజ్ ఇన్ ఎ రూరల్ ఏరియా, even a constable has so much power. The dand of a constable itself is having so much of weight there. City lo aide constable le chances are there. SI ante SI le, CI aide CI le, IPS ade na bold IPS lu unnaru, nene aita repu. You may be thinking like that, okay, IPS aithe emundi, okay, repu nenu kuda aita. What is there? IPS aithe bhayapadala. You may having more knowledge, more awareness and all that. In Delhi, if you go, nobody cares for anybody unless you are the prime minister. Because in Delhi, everybody is a who is who. In Delhi, many people are all ministers, union ministers, all the central staff, secretariat. ఆ ఏరియా మొత్తం లెటియన్స్ ఏరియా మొత్తంలో ఎవరికో ఒకడు తెలుసు. That's why there is a saying that in Delhi, whenever an accident happens or something happens, immediately వచ్చి they say, no, जानता हो मेरा बाप कौन है, means that fellow जानता है मेरा बाप कौन है. Me ayya great and me ayya great. Both are having somebody. Both have some IAS officer, some mama, chacha. Somebody is having, everybody is everybody are under Delhi lo, because people are having such kind of backing. So as you go closer to the city, you may have somebody. But if you go to a village, rural areas, remote areas, if you go, even the sight of a police may frighten somebody. Police kanpichna gani ammo enduku vachir police and all, because that much of knowledge is not there. So knowledge of law is not, knowledge of fundamental rights is not there, knowledge of constitution is not there, awareness of rights is not there. They don't know they are 19, 20, 21, 22. These rights they don't know. And if it is violated also, most of them they are crying, or they are, their helplessness is there. They may not know that I can go to the Supreme Court or High Court. Let us say somebody told them and somebody brought them also, who will afford those services? So seeing all this, in Husainara Khatun case, Supreme Court said that this is wrong. Free legal aid should be there. Legal aid also, some free services should be given if the person is not able to afford it. Afford cheyalekapothe free legal aid service iyali. That is also a fundamental right. Otherwise, what is the meaning? Right to life, so and so rights are there. But if they can't avail because of lack of financial resources, you should not deny them that fundamental right. Ani cheppi, that's why free legal aid is given through legal services cells, legal services authority. If you come to the High Court, you will find a legal services authority kanpistundi. In any of your district courts, if you go also, legal cell kanpistundi. Legal services ekkadundi anante cheptaru vallu. So if you can't afford, if you have an income certificate belonging to SC, ST, BC and all that and all, you can go and check whether you are eligible. If you are eligible, they have to provide you a free lawyer, advocate. You need not pay a single rupee to that person. Stationery, everything that person only will manage. You need not pay him at all. But the person is tagged to you, he should look after your case. So that is what we are saying is free legal aid. Otherwise, poor people will not get justice in the country if you don't have free legal aid. So like that it said in this case. Next, right against solitary confinement. This is also, so this came up with Sunil Batra versus NCT of Delhi అని ఉంటుంది. Sunil Batra case, that person was arrested. From the time he was arrested, he was put in solitary confinement. అంటే జైల్లో ఒక్కడనే వేసి ఎవ్వరిని కలవనీయకుండా అట్లా పెట్టారు. See, even prison also, you should have some kind of public life. Human being is not a solitary being. Human being is a social being. Okay. If let us say, if you are put in your own house also and locked, your own house also, if you are locked, can you live more than 10 days and all? Will you be able to live? సార్ నేను ఉంటా సార్ నాకు మొబైల్ ఇస్తే చాలు ఇంటర్నెట్ మొబైల్ నెట్ఫ్లిక్స్ ప్రైమ్ ఐ విల్ సర్వైవ్ ఎనీ డే ఫుడ్ పెట్టాలి జొమాటో స్విగ్గీ నో దోస్ ఆల్సో విల్ బి టేకెన్ ఆఫ్ నో ఇంటర్నెట్ నో టీవీ నథింగ్ యు ఆర్ పుట్ ఇన్ ఓన్లీ ఇన్ ఏ you won't be able to survive. I will challenge you. You cannot survive. Very difficult. You may think you won't be able to survive. అరే లాక్డౌన్ అప్పుడే ఒక్కొక్కడు బయటికి నేను పోవాలని హౌ మచ్ యువర్ సీన్ దో యు ఆర్ విత్ యువర్ ఫ్యామిలీ మెంబర్స్ అండ్ ఆల్ స్టిల్ యూ వాంటెడ్ టు గో అవుట్ యాజ్ ఇఫ్ సంథింగ్ ఈస్ హ్యాపెనింగ్ అవుట్ సైడ్ నథింగ్ వాస్ హ్యాపెనింగ్ బట్ యువర్ అర్జ్ సీ హౌ మచ్ ఐ వాంట్ టు గో అవుట్ బికాస్ అండ్ అలాంటిది ఇన్ వన్ రూమ్ ఇఫ్ యు ఆర్ పుట్ అండ్ ఆల్ యూ విల్ నాట్ బి ఏబుల్ టు సర్వైవ్ ద ఛాన్సెస్ దట్ యువర్ మెంటల్ హెల్త్ విల్ బి డిస్టర్బ్డ్ బికాస్ man is a social being. Man is not brought into the world as a species, human species. Our mind is attuned to be a social being, not like a solitary being. There are certain animals which only are solitary. Human species is not like that. Homo sapiens are social beings. So if you are put in solitary confinements, you may go under depression. You may chances that you will be mentally so affected. So solitary confinement is there in IPC, but very rarely you will give solitary confinement. For every case and all, you should not give solitary confinement. Suppose, even though not needed, still solitary confinement is given. That is also violating against fundamental rights. That is also violation of fundamental rights. So, right against solitary confinement also comes under Article 21, we are saying. Then, right to speedy trials. So much delay happens in trials. So right to do a speedy trial, you can come to you can file a quash petition in the High Court and all that. One chance is there. Opportunity is also given to come to the High Court like that. So these come under right to speedy trial. For that also, you will see that it is a fundamental right in one of the cases. These are all each one case in the Supreme Court. So right against handcuffing. You have seen handcuffs, bedi. Not in every case, police should not put handcuffs. Only if you are generally a dreaded criminal. No, you are a murderer. There are certain offenders, criminals, who are very, very capable of easily running away. Or, once already ran away, second time they are catching. Or this person is a dreaded criminal, knows the use of weapons. Even that person can convert anything into a weapon. A pen also a key also he can convert into a weapon. These type of people are there. I've seen some people like that in the jails also. Very, very, see, chala mandiki movies have disturbed your imagination of criminals. Criminals ante edo itla undi, rowdy undi, like that they won't be. 90% of them are like, very thin and all. Like our person, just I'm not saying anything. He's మనోడు ఎట్లా ఉన్నాడో అట్లా ఉంటాడు అంతే. Most of them, I've seen most criminals in the jails also, they are like that, very young chap, all that. చూస్తే ఎవరు అమ్మా ఇతర మర్డర్ చేసింది 3 అని అనుకో నువ్వు. You won't think this fellow has done 3 murders or 4 murders, has done, you won't even think this fellow had kidnapped, murdered, ఇన్నున్నాయా వీడి మీద అనుకుంటా. You see, you'll be like that only. Movies mein what they show is, one villain is there, all gym gali. Most of those people who go to gym, they are very nice fellows. Body builders itla andaru anu. Valan papa movie lo villain menkal esi anta kuda chedagottaru. Your view has been brainwashed like that. Most of these people, they are working as bouncers papam. Night mottam bouncers la work cheskoni మార్నింగ్ వచ్చి ఈవినింగ్ ఆఫ్టర్నూన్ నుంచి ఈవినింగ్ దాకా జిమ్ చేసుకొని మళ్ళీ వెళ్ళి మూవీస్ లో యాక్ట్ చేసుకుంటున్నారు, బౌన్సర్స్ గా వర్క్ చేస్తున్నారు. వాళ్ళ పాపం చాలా మంచోళ్ళు, మోస్ట్ ఆఫ్ దెమ్. బట్ మూవీస్ హావ్ పోర్ట్రేడ్ ఎనీబడి విత్ బిగ్ బల్కీ బాడీ అండ్ దిస్ బాడీ ఇంకా విలన్ వెనకాల ఉంటాడు. మూవీస్ జడగొట్టారు మిమ్మల్ని మోస్ట్ ఆఫ్ ద టైమ్స్. అదర్వైజ్ మోస్ట్ క్రిమినల్స్ అండ్ ఆల్ దే ఆర్ లైక్ దే లుక్ లైక్ ఆర్డినరీ పీపుల్, దే ఆర్ వెరీ ఇమాసియేటెడ్ ఆల్సో, బట్ ద మైండ్ ఈస్ డ్రెడెడ్. మైండ్ మాత్రం ఎట్లా ఉంటే వెన్ యూ స్పీక్, సార్ నాకు బెయిల్ ఇప్పియండి సార్ మళ్ళా పొడుస్తావా, లైక్ దట్ విత్ ఆల్ కాన్ఫిడెన్స్ హీ స్పీక్స్. ఒక్కసారి బెయిల్ ఇప్పియండి సార్, మీ కాలు మొక్తా, బెయిల్ ఇప్పియండి. He speaks like that. Young chap, just 19-year-old, 20-year-old. అల్లా పొడిచి సారి లైఫ్ వేయించుకొని వస్తా సార్ నేను. Like that he says, very dreaded criminal is, because mind has been hardened. Mostly mind has been hardened, so much hardened that he wants to commit that offense. So you are putting him in prison and all to reform him, and chances of reformation, లేదు మళ్ళీ చేస్తాడు, life imprisonment or death sentence, rarest of rare, death sentence would have said. So these type you try to do. Anyway, so we are saying that handcuffs should not be given in every instance. Arrest means not handcuff. Again, movies have changed your perception. If you read CRPC, you will see article section 41 and all, you will see arrest is generally committed by holding hand, or if needed, tying rope. Only if needed, then they put handcuffs. Very dreaded criminal, chances of escape are high, then only you will put handcuffs. Every arrest should not have with handcuffs. But movies lo what they show, police officer ante arrest and all that, like that. It doesn't happen like that. These days arrest, for most of the arrest, it is only notice given, 41A notice అంటారు. 41A notice means come to police station, అక్కడ క్వశ్చన్ చేసి అవసరం అయితే అరెస్ట్ చేస్తారు, లేదంటే లేదు. See, I'll discuss that after the class. I'll discuss because they're not required for this one. That is more into law and all. You can, but you will waste the time of the court if you don't know the procedures. It's not necessary to go only through advocate. So he's asking that, is it compulsory to have an advocate? It's not like it is compulsory. You can argue petitioner in person anantam, petitioner in person, or any person, defendant in person. You can argue your case, but most of the times you won't know the procedure, you won't know the law. You'll be blabbering. Sir, atlatleisure sir, nannu judge ane judge time waste avutadi. ఏ లా అమ్మా, ఏ సెక్షన్, ఏ రూల్ అని అంటే అవన్నీ తెలియదు సార్, నాకు వేయొద్దు అని అంటే టైం వేస్ట్ అవుతుంది కోర్టుది most of the times. But if you know all the law, all the procedures, you can argue. There is nothing stopping you, but most of the times you won't know, because you should read law with other laws. Okay. It is not necessary if you only study IPC. You should study CRPC, you should study Evidence Act, you should study cases. అందుకనే అవి కొన్ని ఎక్స్పర్ట్స్ వదిలేయాలి జనరల్ కొన్నిసార్లు. Okay, so or if you are very expert, if you have studied, that much time is there, okay, no problem. So if you are getting a diagnosis, some illness is there, can't you treat yourself? You can treat yourself. Why are you going to a doctor? Because chances that you will misdiagnose చేసి ఏదో అన్నిటికీ డోలోనే వేసుకుంటుంటాం. Okay, anything or not, dolo you will put. Dolo, it doesn't work. But these days, everything dolo. డాక్టర్ వెళ్తే తిడతాడు, అరే బాబు డోలో అన్నిటి కాదురా నాయన, మాకు తెలుస్తుంది. We will know, depending on your symptoms, depending on your conditions, your previous history, how much, what is your blood pressure, what is your infection, depending on all that only we will give. Experts do their experts job. Similarly, can you argue in your own? Yes, you can argue, but you will definitely fall into one or the other mistake you will do. That's why, it is better to at least take free legal aid. You do not know, and you can't afford, then you can take free legal aid. So handcuffing is also not the norm. Handcuffs ishtam unnachchu వేయకూడదు, ప్రతి కేసుకి handcuffs వేయకూడదు. Or even bar fetters also should not be put. Next you will get bar fetters. Bar fetters is also given in exceptional cases. ఏదో dreaded terrorist పారిపోతాడు, అమ్మో, some criminals are so talented, skilled. Any one small piece of metal if they get also, they'll convert into something. They'll convert into a weapon. Small piece of metal they'll convert into a metal. Small blade if they get, they can cut. Such type of people are there. Atlanti వాళ్ళని వాళ్ళు పారిపోకుండా bar fetters are put. Bar fetters means, the legs, see, there will be a bar and tied, so that the person cannot run and all, he can only move like that. A bar with bar and chains, his legs are put in fetters ananta. So bar fetters use చేయడము, handcuffs use చేయడము only in certain cases, not in every case of arrest. Okay, so not to be put like that, because if you are putting like that, you are putting you to shame. So not every arrest should be done like that. That's why this is also against that. Also, you have fundamental right. But if there is a specific law saying that you are a dreaded terrorist, you have committed so and so offense, then you can be put to handcuffs and bar fetters. Then right against inhuman treatment. Nobody should be subjected to inhuman treatment like that. Okay, as if treating like animals or something, whipping them like animals and all that, subjecting to torture, police వాళ్ళు torture చేయడము, or subjecting like animals, they are throwing something on them. ఇట్లాంటివన్నీ కూడా they should not. Right against delayed execution. Execution means executing death sentence. Execution means death sentence. అది too much delay కూడా చేయొద్దు. 20 years, 25 years delay అట్లాంటివి చేయొద్దు. Subject to Supreme Court certain guidelines, you have to follow and give death sentence. Right to travel abroad. This came with Menaka Gandhi case. Menaka Gandhi case, later what happened was, once I didn't tell what happened later. So what happened later was, Supreme Court said that now there is due process of law. Due process of law, that means the law that you made also should not be unfair, unjust, unreasonable. So Supreme Court said that no, you have to give her passport back. So in a way, she won that right of, I have a right to travel abroad. I hope you are understanding. So Article 21 is also covering your right to travel abroad. Whereas traveling within the country, which article? 19, remember? Right to move freely throughout the territory of the country. That is covered under 19. But right to go abroad, come back from abroad to India, these are covered under 21. Those are covered under, right to abroad is covered under 21. Because it is personal liberty. Your personal liberty, I can go abroad also, like that. Unless there are criminal cases against you and there are chances that you are still a criminal and you will run away, you will never come back, then they can be arrested. Right against bonded labor. Bonded labor, forced labor, vetti chakiri, begar, these are all again specifically covered under Article 23 also. It will come under 23 also. Article 23 కింద కూడా వస్తుంది. But here also Supreme Court said, if you subject someone to bonded labor means vetti. You must have heard vetti chakiri. So this is a forced labor, telling that you are bonded to me as a laborer and I want to pay you money. I want to pay you because your grandfather took some loan from me. Your grandfather took some loan from me, or your father took some loan from me. He did not repay, so you should come and work for me. You are bonded to me. This is called as bonded labor. This is called as vetti or begar, we say. So such types are clearly, it is prohibited under Article 23. And if you do any such things, even your Article 21 is also getting violated, and Supreme Court has told. And right against custodial torture, custodial harassment. Police should not subject anyone to custodial torture. Second degree, third degree, whatever degree, if they do, in fact, against police only there can be case if they found out. Okay, sometimes those who are arrested and custody lo baga police have beaten. Sometimes they come before magistrate and show the marks. Sir, marks, but I joined. Police have beaten. Then the police will be suspended. That's why police are also clever. They don't beat here and all. They beat under the feet. Because you will show marks to the magistrate. Judge mundu తీసుకొచ్చినప్పుడు, magistrate mundu తీసుకొచ్చినప్పుడు, they will show the marks. Custodial torture చేశారు నన్ను. So police are also very careful. That's why they beat on hands, knuckles. Okay, under the feet they beat. Because under the feet and all, you may get some red marks, swelling and all, but again it goes back, right? Again it becomes normal after some time. Within 24 hours it becomes normal. Pain is there, you got pain, but after 24 hours you can't show my strength. Where means it's not there, or yesterday it was there, today not. Or they have very creative methods, police have. To break the bones also they have creative methods. Sometimes they are caught, not every time. If the advocate is able to prove that custodial torture, police will be suspended. Okay. But police do all sorts of things. In their own way they try to do. Because sometimes, very dreaded criminals are there, they won't change. They won't change, that's why. But police are not supposed to give punishments. Only the courts only can give punishments. Police should only hand over them to the courts. Police can never punish. Keep this in mind. Police cannot punish under whatever circumstances. However, Law and order problems are there, they can use force. Let us say you went and sat on the road and you are not moving. Police said, go away. You're not moving. Then they will use force. Then lathi charge also they may do. If you become violent and you are shooting, throwing something and all, then they may shoot also. They can use force if necessary. But once they are in their custody, you should not torture them, harass them. So all types of custodial torture, harassment, the so-called third degree, second degree, all these all should not be done. If it is found to be done, the cases will be against the police. Appudu police became criminals. Police are violating now IPC. Up to that time, the person may have committed a crime. Now police also commit crimes. But it is, you are seeing that police, that's why they are saying, put all CCTV cameras in police stations. Some police are putting, some police are not putting. Where you are putting also are not working. Why it won't work? Deliberately they switch off and all these types of things also police do. But when things come to your manch advocate, High Court koste, they will get rap on their knuckles from the judge. Maybe an IPS officer tomorrow. But remember, in front of the judge, no, you are just any other person. Okay? We have now videos also. Nowadays, High Court proceedings videos are coming. Supreme Court, High Court proceedings videos are coming on YouTube. Now live. You may be IPS, DGP ayav. Somebody, civil services rasi, IPS ai, IAS ai, Chief Secretary you are becoming, DGP you are coming. But you have done something wrong. High Court, ra beta. What are you? I am DGP. Don't you know how to do? What training you got? Like that, judges are scolding them in front of everyone. Almost embarrassing them. And YouTube తో ప్రాబ్లం ఏంటంటే ఇంకా అది ఎప్పటికీ ఉంటుంది. డిలీట్ అదే ఇంతకుముందు యూట్యూబ్ లేకపోతే many DGPs, many collectors, IAS officers, they also got from many years they have been getting scoldings in the High Court. But now live streaming YouTube ఇంకా అవన్నీ అట్లా పడి ఉంటున్నాయి. అందరూ ఆ వీడియో చూస్తున్నారు. వీడియో IAS ఆఫీసర్ మంచిగా పడ్డాయి హైకోర్టు. దే ఆర్ సేయింగ్ దీస్ డేస్. That's why, your conduct should be above all that. These type of things if you do and if you are getting caught. So there are many now High Court, even Telangana High Court also many times. Even Madhya Pradesh High Court, Guwahati High Court. They are scolding. Don't you know, your IPS officer, don't you know that how can you subject to custodial torture? What law gives you permission to give punishment? నువ్వే అన్ని చేసుకుంటే ఇంకా మేము వెళ్ళిపోమా? మూవీ సంథింగ్ మీరే వేసుకోండి అయ్యా మేము వెళ్ళిపోతాం అని బ్రహ్మానందం అన్నట్టు. లైక్ దట్ ఓన్లీ మీరే పట్టుకొని మీరే పనిష్మెంట్ ఇచ్చుకునేది అయితే మరి వై ఆర్ కోర్ట్స్ దేర్? వై షుడ్ కోర్ట్స్ బి దేర్? కోర్ట్స్ ఆర్ టు సీ evidence after evidence and everything carefully, and like that only you have to punish. Otherwise innocent will be punished. Like I told you, police can catch randomly somebody, some orphan will be there, some beggar is there on the street, some crime is there. You are all shouting, crime is increasing in society, crime is increasing in Hyderabad. Then they'll bring 10 beggars and say, they'll put masks on them. Yesterday we caught 10 criminals and all. They'll put a press conference. Are they really they done or they don't know? How do you know? Who చూసావా? Police are saying, police చెప్తే 100%. Nothing like that. Courts will determine based on evidence. What evidence is there? Where you have caught? How you have caught? Who gave information? All that police diary, everything will be checked in the courts. Then only you will get punishments. Only courts can give punishments. Police should not give punishments. But in India, culturally also, society also is grooming children also in such a way. Movies are also showing in such a way that police have a power to punish. And society also is thinking in such a way that police వాళ్ళు తీసుకెళ్ళి పదేస్తే మంచిగా అవుతాడు. They are thinking, police should take and they should beat him, they should give punishment. So the expectation is from police is not just to control and put law and order, but your expectation is police should punish also. That's why they are thinking we will punish also. But police should not punish. Only the courts should punish. There is a criminal justice system. The system is in place. Only that will give punishments. Police are not supposed to punish. But if they do any kind of such kind of custodial harassment, okay, custody lo AC కొట్టడము అట్లాంటివన్నీ చేస్తే very creative techniques they use to escape from law. Very creative techniques. They will break bones, but they will tell that sir he fell from the bridge. When we were chasing, that's what they create stories. When we were chasing on Narayanguda flyover, This person, seeing us from behind, he jumped from the flyover and broke his leg. That's why this fracture came. In reality, they would have tied 2 bricks that side, this side, beaten him, the leg gets broken. That's what they do sometimes. Atoka brick, itoka brick, atoka stone beti, baga badite kale roots. Yeah. They will create like that. Story they will create like that. Just to tell. అడుగుతారు అంటే అది అడగాలి కదా, అటు సైడ్ డిఫెన్స్ వాడు కూడా అడిగి గట్టిగా పట్టుకుంటే అప్పుడు దొరుకుతాడు కొన్నిసార్లు. బట్ ఇట్లా ఐఎమ్ టెలింగ్ యూ వన్ ఫ్యూ ఇన్స్టెన్సెస్ వేర్ పోలీస్ క్రియేటెడ్ సచ్ స్టోరీస్. కాలు ఎలా ఎరిగింది అని మెడికల్ రిపోర్ట్ వస్తుంది కదా, మెడికల్ రిపోర్ట్ ఏం చెప్తుంది? మెడికల్ రిపోర్ట్ వోంట్ సే ఇట్ హీ ఫెల్ ఫ్రమ్ నారాయణగూడ బ్రిడ్జ్, ఇట్ వోంట్ టెల్. మెడికల్ రిపోర్ట్ విల్ సే ద నీ ఫెల్ ఆన్ ఏ హార్డ్ సర్ఫేస్ అని. అంటే ఏంటి హార్డ్ సర్ఫేస్? స్టోన్స్ కట్టారు అటు ఇటు, ఫాల్ వాటర్. సో దట్ ఈస్ వాట్ దే డూ. ఎనీవేస్ దీస్ ఆర్ ఆల్ ట్రిక్స్ దట్ దే యూస్. బట్ these days, that's why, these days there are many mobile phones, easily recorded. Anything you do, custodial torture also, some constable records and all that. Some movie also came, no, Bhimla Nayak something and all. Itla evodo okati record chestadu, edo okati easy ga doruktaru. Enduku kashtabadi pass ayi civil service exam pass ayi aadaga job దగ్గర కింద తెచ్చుకుంటారు. That's why, follow law. As law is there, that much you follow, you will be safe. Don't become Singham type of officials, compulsorily they'll get suspended. Keep this in mind. Don't take law into your own hands. How much law tells, that much only you have to follow. Don't become, I'm IPS officer, now I will, ఇప్పుడు అయిపోయాను IPS officer. ఇప్పుడు నా లిస్ట్ లో రివెంజ్ లిస్ట్ ఇస్ దేర్, టేక్. ఓకే, ఇన్ మై కాలేజ్ వన్ సీనియర్ ర్యాగ్డ్ మీ. ఓకే, ఇట్లాంటి అన్ని చేసావనుకో నీకు అంత, యు ఆర్ ఆల్వేస్ బౌండ్ బై లా. పీపుల్ విల్ అబ్జర్వ్ యువర్ యాక్షన్స్. దెర్ ఆర్ మెనీ IPS officers who are in jail now, the country. There are IPS officers who are in jail in the country. Some of them life sentence, some of them 10 years, some of them 5 years. So don't become trigger happy, do fake encounters. Itlanti anni vaatlo ellavante, at some point you will be caught. Maybe this government will protect you. When the government changes, who will protect you? Andukane, so you should, governments may change, keep that in mind. Today one government is there, next another government will be there. Let us say this government protected you, next government will not protect you. Appudaina jail ki potavu kada. So that's why better, safe side is follow constitution, follow law. Safe side. If you think that chief minister ఏం కాదమ్మా నువ్వు చూసుకో నేను ఉన్నా కదా అని అంటే, నువ్వు ఇలా ఉంటావు సార్, రేపు పోతే పోయేటట్టు నువ్వు 5 years తర్వాత, then who will protect me? Because he is only political executive, you are permanent executive. He is political executive, you are permanent executive. మీ జాబ్ ఉంది, career ఉంది, you will get disturbed. So don't resort to such things and unnecessarily get into trouble. So no custodial torture and all, it is against fundamental rights. You are becoming criminal now. Custodial torture and death happened. Many instances of custodial torture and death, custodial death anantam. Custody deaths are serious. Whoever are in the police station, all of them may get life imprisonment. Police custody lo, in the police custody, rape or death happens, then you'll get, entire police station may get sentence, life imprisonment పడవచ్చు or 10 years imprisonment పడవచ్చు. Serious it is taken, because police custody means itself there is safety should be there. అట్లాంటిది police only, తెలుగు విసే రక్షకులే భక్షకులు అవ్వడం. So like that you cannot never become. There are cases in which custodial harassment, custodial rape, custodial torture, these all the police personnel have faced murder charges. Recently in lockdown also in Tamil Nadu, there was a case during lockdown. One father and son were subjected to torture. Phoenix and Felix, one father and son, they did not shut down their shop on time. So police have taken them, they have beaten them black and blue and they died. Custodial deaths. Entire police station is now, they are facing charges of murder. They are in prison now, police wall. So that's why, this type of custodial torture are not allowed for. So that also is under Article 21. You are right against such torture. Right to emergency medical aid. Emergency, something happens and all, medical aid, suddenly you are rushed to a government hospital, suddenly you called for some government ambulance. These all, they have to be there. Okay. So if you are brought to a hospital and all, they have to treat you, emergency medical aid. So that also subject to the availability of doctors and beds. You can't say during Corona time, many people rush to government hospitals. If they don't have beds, what they can do? If they don't have oxygen, what they can do? They have filed Article 21, they have filed. But Supreme Court also said, government take all measures. Government is saying, we are taking all measures. But andakante oxygen ledu. Supreme Court scolded also. Corona vastunde teliyadu government should be ready. Like that, it has scolded, but still, due to lack of oxygen, also many people died. You also know during the second wave time. So, yes, you have a fundamental right to emergency medical aid, right to timely medical treatment in government hospital, right not to be driven out of a state unless there is a reason for your expulsion. You have a right to remain in your state, not to be driven out of your state. Only extreme situations only you will be asked not to return to Telangana, not to return to Karnataka, like that, only exceptional situations. Otherwise, you can remain in your state. Right to fair trial. A trial must be fair. Trial in the court, when trial is happening, it should be fair. Fair trial, when we are speaking about fair trial, it is a principle of natural justice anandam. Okay. We say this is a principles of natural justice law, Bhagam. This is important. Why don't you just write it down? Right? Principles of natural justice. Write in a separate para. Principles of natural justice. And this first one you write down. First principle is Audi alterum partem. Audi alterum partem. These are some of the Latin, Greek maxims untai, meaning in brackets you write down. Here the other side, here the other side, or here the alternate side. Here the alternate side. And under that you write down, this is a right to fair hearing. This is a right to fair hearing. Where all the parties are given a chance, and heard at the trial, right? Second one, nemo judex in causa sua. Nemo judex in causa sua. In brackets, no person shall be a judge in his own cause, his or her, హిజ్ ఎక్కడైనా హిజ్ అని ఉంటే హర్ కూడా అమ్మా. ఓకే, లాలో is her, you will see. Constitution also, wherever you see his, it also means her. So his or her own cause, brackets close. Under that you write down this principle is of unbiased judgment, is of unbiased judgment. Okay, so these two principles we say are principles of natural justice. If we follow aitene we say it is fair trial. If you don't follow this, it is unfair trial. These two principles are very, very important for doing justice. In our daily life also, these principles apply if you want to do justice. Let us say your two friends fought and they came to you. Okay, so let us say this, Dheeraj and our Sunil fought. Okay, Dheeraj and Sunil fought and they came to our Zahir దగ్గరకు వచ్చారు. So first, Dheeraj told everything about Sunil. So, actually he did that, actually he did this, that's why, and all he's telling. You only tell justice. So hearing only Dheeraj, now Zahir is giving judgment. Yes, Sunil is a wrong fellow, okay, unscrupulous fellow and all like that he is taking. Sunil is saying, hear my version also. What your version? Nothing. I'll hear only one side. Is this fair trial? So you have to hear the other side also. Hear the other version also. If there is a third version, you have to hear the third version also. That hear the other side only we call as audi alteram partem. Every version you have to hear. Court hears the other version also. Without hearing version, you should not do fake encounters and all that. Maybe there is a version, you don't know. There could be a version. We are not saying 100% there will be, but there could be. Without hearing, you should not take judgment. Many times your friends also came here, say they will tell about Chadil చెప్తుంటారు ఇంకోరి మీద. You know what happened yesterday? She told like that about you. Like that they come and tell. Auna, how she can tell about me like that? This person also goes. You go and ask other side also. Did you tell like that and all? Maybe he is only telling lies. So that's why we have to get the other version also. Only one version and you should not make a judgment. That is audi alteram partem. So court also it hears the accused version also. So that's why we are saying that this is a fair hearing. All the parties are given a chance to tell their version. That is what audi alteram partem. That's why it may be Ajmal Kasab, it may be a rapist, murderers also. Once let us hear what he wants to tell. Did he really do it or somebody pressured him to do? We don't know, right? Somebody may be having a pistol to their mother and asking you to do a crime. Then he's doing the crime. Should we also give death sentence? No. So it depends on what circumstances he did also we have to check. What only TV is showing you, media is showing you, what police is showing you is only one version. There may be other version, what we call as a defense. In his defense, he may have something. So let him bring. If it is not actually matching to what he is saying or it is not true, then we will still give punishment. But once you have to hear, so that is what we call as audi alteram partem. Okay, audi means here, alteram means other party, other side also. Then nemo judex in causa sua, we say that you should not be judge in your own cause. That is what sua means, own cause. Don't be a judge in your own cause. Means, let us say I'm a judge and I'm sitting. Okay, and then when I'm sitting, nicely sitting in the court in judgment, then suddenly police brought accused person. The accused person, the moment I saw, is my old classmate. Hey mama bagunnavada, hey hello, how are you? He's వచ్చాడు sir పట్టుకొచ్చాడు. Hey, don't worry, I'm there. Now what is happening? I have a bias. Will I give fair judgment? No, I may not give. I may not give a fair judgment now because I know him. Or he may be my relative. He may be my student. I should not show bias here. So this is the principle of unbiased. You should be unbiased. So it is against bias, or you can say principle of unbiased judgment or principle of no bias. You can write anything you can write. Principle of no bias you can say, or unbiased judgment. You cannot have bias. So in your own cause means you have own your interest. Some interest is there. Your family member, your relative, your business partner, some link is there with that person. So you should not be in that judgment. What you should do is you should recuse. If you know that person or somehow linked to that person, the judge should recuse, say put it before other bench, other court. Inke vere judge evaraina chudali. You should not sit in that judgment. I hope you are understanding. So the judge, if at all, if he comes like a situation, he should recuse. Not rescue, this is a recuse. Recuse means he should not sit in judgment, because now his own judgment is there. If his own interest is there, own cause is there, then what happens? Then it is not, it is biased. You have a bias, you have partiality here. So that's why this is also an important principle. Okay, that's why did we do away with the so-called Pedarayudu system and all in villages, Kap Panchayat, all those? Because there is so much of bias. Hey, mana caste people, hey, mana kulapode, and all these things come there. And moreover, that fellow doesn't know law. Okay, so that's why, you know, such kind of punishments and all should not be given. And the judge who is sitting also, he should see that, you know, no kind of interest is there. Not to the other side also. He should not be a friend to the government also. That's why independent judiciary, we said. Judiciary should be independent. Why? Because if judiciary and executive are too much in friends, what happens? Police wala version all, he will listen. Police said that, sir, he is criminal. Yesterday we caught him. Oh, no, criminal, huh? Okay. What he did? So the prosecution side is saying, means police, on behalf of police, the prosecutor, PP unted, public prosecutor, or APP, assistant public prosecutor. They are saying, sorry, yesterday he ran on the bridge, he fell from the bridge, he did some theft, he did all that. Oh, no, face judagana atlane kanpistundana. Can the judge be like that? Can a judge presume that you guilt? No. Pakka criminal andi. Face, veshadara chudagane kanpistunda. Sir, my version, what your version? Get lost. Can you be like, no? That's why that will be bias. That's why in criminal justice system, have you written this? That's why we say presumption of innocence is there until proven guilty. Guilty అని ప్రాసిక్యూషన్ ప్రూవ్ చేసేంత వరకు వి డీమ్ దట్ నార్మల్ గా ట్రీట్ చేయాలి. తీసుకురాగానే పోలీసులు తీసుకొచ్చారంటే క్రిమినల్ అని అనుకోవడానికి లేదు మ్యాజిస్ట్రేట్. సి బికాస్ దట్ ఈస్ క్రియేటింగ్ బయాస్ ఇన్ యువర్ హెడ్, రైట్? సి ఫర్ ఎగ్జాంపుల్, if you see now a police is, let us say police is three police are putting someone tying a rope and they are taking, what comes to your mind? He must be a criminal. There is a presumption in your mind already that criminal kabatti police pattukoni untaru. That is your presumed deemed guilty you are getting, not deemed innocent. But let us say if judges already have that, already they are thinking that he is guilty, how will they do fair trial? A judge should start from the point of zero and then see which side. That's why you see the scales. See the lady of justice, lady of justice has scales, and you are tying a black ribbon you are tying. Why are you doing that? Because you should have deemed innocence. And then okay, let me start from the scratch. Tell. So you tell, I will hear. Based on the evidence, I'll give justice. It cannot be first seeing, looks like a criminal. Maybe that fellow is a beggar on the roads. Police have caught him. He is all very rough and all, he is looking like that. This must have been a criminal. If you already started, if the judge already has a presumption that he is a criminal, he will think, he will believe whatever the police says, rather than looking at the actual evidence. So that's why you should start from the point as if, okay, let us start from the point of innocence. Now you tell your charges. What are the charges? What are the evidence? Show me. Based on that, now you tell what is your defense. Based on that, I will give punishment or not. I may hold guilty or I may acquit. Remember, conviction, acquittal. Either you may convict or you may acquittal in criminal cases. So that is how you must start. There should be presumption of innocence, or we are saying deemed innocence until proven guilty. Deemed innocence until proven guilty. If he is proved guilty, we will give punishment. Otherwise, we will acquit. Because no innocent person should be punished. No innocent person should be punished for what he has not done. You have to not punish. What do you study in Article 20? No ex post facto law, what you are studying? No person shall be punished except for a law on the date of commission of that particular offense. Are you not studied? Okavela law undali, and this fellow should have committed an act, and you should not give greater punishment, greater penalty than that law. Should not punish. That's why we are saying presumption of innocence untundi. Deemed innocence is there until proven guilty. That's how you have to start. You should not start, must have police తెచ్చారంటే పక్కా criminal. Police may have brought somebody, you don't know. So that's how we must start. I hope you understood what are principles of natural justice. In that only we speak about right to fair trial, right to hearing. Both of them, they in a way they come under this principle. Next, right of prisoner to have necessities of life. Even prisoner also has some necessities of life. So basic necessities, food, water, washroom facilities, even books. Okay. These days, prisons, how has anyone visited a prison? Mulaqat kuda eppudu boleda? Poinda? Gone? You have seen how the inside of prison is? These days, prisons are like hostels only. They are no different from here. If they are a well-maintained prison, if they are a well-maintained prisons, open prisons and all, some of them are Challapalli prison and all, you'll say, పెద్ద డిఫరెన్స్ ఏం లేదు. మీకు సో కాల్డ్ పారాయణ, ఫైతన్య హాస్టల్స్ అదేనో అట్లనే ఉంటాయి. అది కూడా దాదాపు అంతకంటే పెద్ద డిఫరెన్స్ ఏమి ఉండదు. ఓకే, similar to that, but you don't have that much of rights and all. You don't have. There is a TV time, there is a prayer time. You have to get up morning, you have to follow some meditation, yoga you have to do, again you have to do. Only for RI people ki hard labor chepistaru. RI means rigorous imprisonment. You have simple imprisonment, rigorous imprisonment. Katina karagara shiksha. Those who are given rigorous imprisonment, they will have to do hard labor. Physical work, lot they have to do. Because they are hardened criminals. That's why all that energy and all that anger, like I told now, will murder and all that, that should be toned down by making them do hard physical labor, and we have to juice ni తీసేయాలి కొద్దిగా. That's why hard physical labor is given to that persons. Simple imprisonment is somewhat like a hostel only these days. Okay, and they are made to, just that they don't have liberty. Once in a while mulaqat is given, family members will come and they'll be scolding. ఎందుకు చేసి సచ్చినవారు అందులో కూర్చున్నావు అని అంటే, మంచిగా ఉంటే అయిపోయా కదా అంటే, దట్ విల్ ఆల్సో మంచిగా ఉంటే అయిపోయాను, ట్రై చేయరు అదే అడ్వకేట్, మంచి అడ్వకేట్ని పట్టుకో. దిస్ ఓన్లీ హ్యాపెన్ డ్యూరింగ్ ద ములాఖాత్ అండ్ ఆల్ దట్, jail visit time and all these things happen. So, but in prison you should be given some facilities. Basic facilities should be there. These days, TV time is there. Some kind of, they can write, sometimes they are allowed to write letters. Some of them are preparing for civil services. Some of them are preparing for law and all also. Some of them are preparing because they have at the time of trial, under trials, they may be released also. They may be acquitted sometime later. If they are under trial, they may be acquitted, right? It need not be proven. So there are people who are completely convicted. Some of them are under trials. Under trial and trial inka complete avaledu, but they are in jail. Right now they are in jail. They did not get bail. So they are still, trial is going on. Such people, they are prepared for exams also. Some of them prepare for civil services also. Some of them prepare for judicial service also. అక్కడికి వెళ్ళాక అర్థమవుతుంది, oh, I should also become all that they will realize. Anyways, so there should be some necessities of life in prison also. Okay. Right of women to be treated with decency and dignity. Women to be treated with decency and dignity. So this is also a fundamental right. Okay, that's why there are offenses relating to even outraging modesty and untai. IPC, there are sections. Okay, not that you have to by heart, just I'm saying 354A, 354 untundi, then 354A, B, C, D and untai. Also 509 section. These are outraging the modesty of women. Any lewd gesture, sexual harassment, intent to disrobing women, all that what we call as Duryodhana Dhritarashtra type people. Okay, voyeurism, stalking, voyeurism and all, making videos of women without the consent. Okay, all that is voyeurism, stalking. 354D compulsory stalking, following women. Explicitly for asking personal interaction, the woman says no means no. Still I want to, but movies, how they are showing, Sagam movies are, they are doing this. Movies are showing, what does youth know about law and all that. They are saying their favorite hero. Favorite hero, what he is doing? Not only is he stalking, another 20 people is taking and stalking behind the girl, and the entire song is there. And Mali ee రోజుల్లో కూడా that song is, I recently watched some one another advocate friend showed me one Kannada song. It became a hit also. One hero, that Arjun's Sarja something is a Karabu something Marabu some song. Okay, I don't know. Karabu only that song. That fellow is going and he's taking 40 people behind one girl. It is clearly 354D stalking adi. That is punishable. So whenever I watch movies and all, ఈ sections అని కనిపిస్తుండే ఇన్ని offenses people కి చూపిస్తుండే. See, what will a youngster just in college seeing such things, he will think that my favorite hero can go behind girl, even if the girl says no also, I can go behind her. See, he's also getting those ideas only. Oh, my hero is doing, means I can also do. See, when you are in a celebrity position and all, you should at least I won't find wrong with the hero. Whoever is writing that script, director, they should have some common sense. Clearly they are showing, they are abetting, in a way, crime, saying that you can go behind women even if they say no also. Some people become very clever. Just she said no, then she is also coming and dancing later. Heroine also joins, then no, everything is fine. Like that they are showing. It's a clear event of stalking and all. The offense under IPC sections. Or voyeurism, taking videos or sending the videos of girls and all without their permission. So, or sexual harassment, outraging the modesty of women, disrobing women, all these things, making gestures, sexually colored remarks, all these are offenses. Serious punishments untai వీటిలలో. Insulting women with words and all, insulting the modesty of women, IPC 509, ఇవన్నీ, these are all complaint వెళ్తే అప్పుడు ఉంటుంది మజా. Okay, so most times complaints are not going, that's why they are not getting away. Once the complaint comes, then they are booked. They are crying, sir, save me. Aim save me. How to save you? You have done clearly offense is there. Evidence is there. These days, she teams are going on with evidence. They are catching you. They are recording everything with mobile phone and all. They are recording. Police also very careful. She teams. They are only in the bus stands. In mufti dress and all, women constables are going and all, and they are recording. Eve teasers are there, coming on bikes, doing stunts around that girl. Everything recorded. In front of magistrate is played. Abba, baga iccharra నీకు బైక్ మీ డాడీ వాళ్ళు అని అంటున్నాడు మ్యాజిస్ట్రేట్. బాగా చేస్తావు నువ్వు ఫీట్లు, జైల్లో జైపో వేస్తారు. Okay, these things. Okay, you do somewhere in a ground, you go and you fall down, break your bones. That is another thing. Around girls and teasing and all that you are doing comes under these offenses, comes under stalking. Not only that, these days cyber stalking is also comes under stalking, 354D. Cyber stalking, sending Facebook messages, requests and all sending. Luckily there is a blocking option, something blocking. మన ప్రబుద్ధులు మామూలు కాదు. దే ఆర్ యూజింగ్ జీపే, లింక్డ్ఇన్, ఏ పెడితే అందులో కూడా మెసేజ్లు కొడుతున్నారు. ఓకే, నో అని చెప్పినా కానీ మళ్ళీ ఆల్ దోస్ బికమ్ అఫెన్సెస్. తెలియని తత్వంలో ఇవన్నీ చేస్తున్నారు, మూవీ ఇన్ఫ్లుయెన్స్లో ఇవన్నీ చేస్తున్నారు, కేసులో ఇరుక్కుంటున్నారు. వచ్చి యూ షుడ్ సీ ద పీపుల్. వన్స్ ద కంప్లైంట్ గోస్, దెన్ ద మజా విల్ స్టార్ట్. అప్ టు కంప్లైంట్ డజంట్ కమ్, నథింగ్ విల్ హ్యాపెన్, ఐ కెన్ డూ. ఓకే, మై హీరో ఆల్సో డిడ్, ఐ విల్ ఆల్సో డూ. హీరో డిడ్ ఇట్ ఇన్ ద ఫిలిం, యూ ఆర్ డూయింగ్ ఇన్ రియల్ లైఫ్. come to courts, కోర్ట్ చక్కలు కొడతా ఉంటారు డైలీ. ఐ విల్ సీ దమ్ ఇన్ ద కోర్ట్స్. సార్ చిన్న చేసిన సి అండర్ అవర్ లా, అండర్ అవర్ క్రిమినల్ జస్టిస్, innocence of so not knowing law is not an excuse. నాకు లా తెలియదు, నాకు ఇట్లా ఉందని కూడా తెలియదు, ఈజ్ నో ఎక్స్క్యూజ్. వి సే ఇగ్నోరెన్షియా ఫ్యాక్టీ నాట్ ఎక్స్క్యూజ్ యాక్ట్ అని అంటాం. అంటే you not knowing that law is not an excuse అని చెప్తుంది. Suppose you just never you came to Hyderabad, first time never you came to any town, any city, but you have a bike, you crossed a red light, challan padada, padtadi, there will be challan. I don't know that red light means you should stop, means you don't, not knowing law is not an excuse, you will still get punishment. That's what, I don't know that stalking is a crime and all. The woman goes and complains, show that I blocked him, I said no, still he's trying to message always, and then the police will come and arrest you, produce you before magistrate. So that's why you have to be careful when, many movies are also made these days about consent. So say consent, does the woman, she gave consent to talk, she gave the consent to have interaction with her, or even to the extent of having, a sexual intercourse or affair and all that. Otherwise it will become rape. Otherwise it will become rape. It will come under outraging modesty and all this, it will come. That's why, have to be careful. Anyways, so right to treat women with decency and dignity is there, but that is also a fundamental right, we are saying. Right against public hanging. If we hang someone to death also, it is not in front of all the people. Of only movies, that is also only in movies. In movies they are showing hero comes, 1,000 people are there, he is coming to the gallows and is giving one big speech, he is giving, oh my people, all that and all he is saying. In independent India, British times some they have done, but in independent India, never happens. Only in the jail premises, only they do. That too in a secret. They don't allow public hangings. We only have against public hanging you have a right. Right to information. I told you, even information also, under 19 also it is coming, under 21 also it comes. Right to know, right to information. Right to reputation. I told you, right, dignity, somebody has a reputation. Defamation kindiki తీసుకొచ్చాం in fact. So you have a right to have some reputation also. That is also a fundamental right. Right to appeal from a judgment of conviction. Suppose you got conviction, you are held guilty by a court, you can appeal to the higher court. So if you felt that no, ee court lo naaku justice jaragaledu anukunte, you can go to the higher court. That is also there. Right to social security and protection of the family. So your family, its basic protection, that also is like a fundamental right. Right to social and economic justice and empowerment. We discussed what is social justice. So anyway, right to social justice is also like a fundamental right. In one case, Supreme Court said these are all fundamental rights. Right against bar fetters, I told you, keeping those bars or handcuffs. Right to appropriate life insurance policy. So in one case, one deceased person, suppose somebody was suffering from some kind of illness, he applied for a life insurance policy. So LIC people, they denied him life insurance. No sir, you have diabetes, you have certain condition, we won't give you life insurance. So the person went, why can't I have life insurance? Then court told that there is a fundamental right to even life insurance also. You increase the premium. That's why today if you have any health conditions, your premium will be higher. If you are paying any life insurance or any other insurance, if you have some conditions, your insurance will be higher. Premium, in the premium gattalo high untundi. Or if your age is high also, your premium will be high. At a young age, if you take life insurance, you will have very less premium. The older you are or you have certain health conditions, your premium will be high. But completely denying the health insurance policy is against fundamental right. Ani Supreme Court in that case it said. Right to sleep. Right to sleep peacefully without this noise pollution and all that. That is also a fundamental right. Night time you got DJ పెట్టేసి మిమ్మల్ని disturb చేయడాలు and all that. If you do, you can call the police will stop all those noises. Okay, all those nuisance noise pollution in the night time, because you have a right to sleep peacefully. Important thing in life is also sleep. Sleep is you can't survive without sleep for 3-4 days. You won't be able to survive. Sleep lekapothe your mind will go, you'll fall unconscious. Okay, so that's why right to sleep is also like a fundamental right. So you need a proper sleep, and all those environment should be in a peaceful. That's why night time they won't allow loudspeakers and all that. If anybody is crackers and noise they are doing also, police go immediately, patrol vehicles go and say stop, band karo, they'll say. You can't say my right to celebrate and all. Means that is there only from, it is subject to other fundamental rights. Your fundamental right is there, other fundamental right is also there. You can celebrate morning time, Diwali time, up to 10 o'clock, up to 9 o'clock, like that they are putting time. Up to that time only you have to fire crackers. Night, but some person will be there. Generally during Diwali, you think up to 10 o'clock they say, but people do up to 12 o'clock. Then at 12 o'clock you slept. Suddenly at 3 o'clock one fellow will be there. Okay, again 1,000 wala he'll put, 10,000 wala he'll put, and all, he'll wake up everyone in the colony. Police will తీసుకుపోతారు అట్లాంటి. If you catch him. Right to freedom from noise pollution. Similar, you have somebody is keeping loud voice or loud volume, and they are doing also. police are called and all, they'll come and they will hold you. So you can't say my fundamental right this is. My expression, you may say. Your expression is subject to other fundamental rights. Okay. Public order is also there, freedom and speech and expression. Other people also have to enjoy their fundamental rights. Right to electricity also, basic electricity connection. This was a case where, a village was there. In that village, all of them have electricity. One house was a little away, but they got a permission from the from the Gram Panchayat, and it was there. All of them were given electricity. This person applied for electricity, not given. He went all the way to Supreme Court. Why? Electricity is also my basic right, right? So these days, what were once luxury, today they became basic rights. Okappudu education was, expensive. Today it became a basic right. At one point of time, electricity was considered only as a luxury at some point. Today it is a basic right. Without electricity, we can't do anything. Like that it has become. So that's why, right to, so they said that no, once you have given permission to construct house, why you won't give electricity? Like that, court has scolded. That's why, you have to give electricity, even if it is a little far off also. Like that, saying that, electricity also forms, it makes one's life living with the dignity. Living with the dignity today, electricity also has become important. Okay. So these are all coming under your fundamental rights, like that court has told. So today you have a homework. Okay. Now you understood various cases Supreme Court told about these all come under right to life or right to liberty. Either they are coming under life or they are coming under liberty. So the question is, you have a right to life. Do you have a right to die? Right to life is there. Is right to die also is there? Hey, my life I will die. Who are you? People may say, hey, my life? You are saying my life I have control, right to live. Does it mean that I have a right to die also? That is first question. I want you to go home, and when you go home, research a little bit and write at least 2-3 paragraphs on each of them. See, such type of questions, alternative thinking questions will come. Edo book lo unnadi okate bahad cheskoni eladamu exam lo vastayani anukodam kaadu. UPSC paper setters will think like this. Because all of you are studying a right to life. I know 21 right to life, right to life. Right to die? Arante daya idena. So that's why, such type, because there are cases also are there. Study about that Ratinam case and Gyan Kaur case. You study about them and write down in your notes. Next, is right to die a fundamental right or not? Okay, why? How? So avanni research chesi write down at least one page. I want you to write down today. Okay. Next, is right to internet a fundamental right? Is it a fundamental right? We are saying right to electricity is a fundamental right under a case. Supreme Court said that this also comes under life with the dignity. So what about right to internet? These days internet has also become, it is no longer a luxury. Okay. When we were studying, internet was a luxury. Okay. We have to, pay so much just for, 1 MB. GB kaadandi, 1 MB kosamu, you have to shell out like, 50 rupees or something just to get 1 MB. అది కూడా అది కేబీలో ఇట్లా ప్రాసెసింగ్ చేసుకుంటూ వస్తూ ఒక ఫోటో రావాలంటే వెయిట్ చేయాలి. నౌ యూ హ్యావ్ వైఫై రౌటర్స్. ఒకప్పుడు ఐ డోంట్ నో ఇఫ్ యూ హ్యావ్ మోడెమ్స్ ఉండేవి. ఓకే, సో త్రూ బిఎస్ఎన్ఎల్ యూ హ్యావ్ టు గెట్ అండ్ యూ హ్యావ్ టు పుట్ ఇన్ డెస్క్టాప్ మోడెమ్. టెలిఫోన్ ఓన్లీ యూ హ్యావ్ టు పుట్, అండ్ అది మెల్లగా ఇట్లా లైక్ 5 kbps 2 kbps అట్లా. నౌ యూ హ్యావ్ జీబీపీఎస్, MBPS ఉన్నాయి, అప్పట్లో KBPS. సో ఒక ఫోటో ఓపెన్ అవ్వాలంటే slowly it will come. One photo we used to send in mail like that. These things used to happen. Today you are getting so much of GB and all that. So today it's no longer a luxury, it is a must. Internet, like if WhatsApp is down, people are sure, what happened to the world? Okay, like that. Or internet is down means unthinkable of these days. You are surviving on internet. అయ్యా నేను క్యాష్ కూడా తెలియదు, జీపే చేయాలి ఎట్లా, ఆల్ దీస్ థింగ్స్ ఆర్ డిజిటల్. పేమెంట్స్ బికేమ్ డిజిటల్, యువర్ రీడింగ్ స్టడీయింగ్ బికేమ్ డిజిటల్, టీచింగ్ బికేమ్ డిజిటల్, ఆల్ దీస్ ఆర్ బికమింగ్ డిజిటల్. ఇంటర్నెట్ ఈస్ సో మచ్ యూజ్ దేర్. బట్ స్టిల్ under our, as of now, are we still treating it as a fundamental right or not? Go and do some research, search in the Google, find out and write down. Next class we will discuss a little about it. Okay. If you want a 5-minute break, please take 5-minute break. Just 5 minutes. If you delay, I will also delay. State. కాకపోతే మీరు నాయిస్ చేసినా కానీ మీరు అతన్ని అనడం కాదు, మీరు పోలీస్ వాళ్ళు వచ్చి పట్టుకుంటారు. కానీ ఇల్లోడు నాయిస్ చేస్తుంటే రైట్ టు స్లీప్ ఉంది, సో మీరు ఏం చేయాలి? పోలీస్ వాళ్ళకి చెప్పాలి. పోలీస్ వాళ్ళు యాక్షన్ తీసుకోలేదు అనుకోండి, సుప్రీం పోలీస్ వాళ్ళు చేయాలి పని, కమెంట్ స్టాప్ ఇట్, చేయట్లేదు, అప్పుడు ఈ ఫండమెంటల్ రైట్ వైలేట్. చేసే అతను మీ ఫండమెంటల్ రైట్ ని వైలేట్ చేస్తున్నాను డైరెక్ట్లీ. బట్ నీకు ఎవరికి యూ కెన్ గో టు సుప్రీం కోర్ట్, హైకోర్ట్, ఓన్లీ స్టేట్ డజంట్ యాక్ట్. దానికి వ్యతిరేకంగా డైరెక్ట్లీ యూ కాంట్ గో టు ద సుప్రీం కోర్ట్. స్టేట్ యాక్షన్ తీసుకో. Depends on what case, depends and whether you have been charges ఏమయ్యాయా, చార్జ్ షీట్ వచ్చినా లేదా చూడాలి. అండ్ ఫైనల్లీ అది రిటల్ అయితే ఓకే, బట్ కన్విక్షన్ అయితే కష్టం. సార్ జైలు అంతా కంప్లీట్ చేసి కానీ ఐ మెన్షన్ అప్పుడు ఫాలో ఆన్సర్స్ గ్రాడ్యుయేషన్ అండ్ ఆల్ వాటికి ఏం ప్రాబ్లం, అన్ని కంప్లీట్ గ్రాడ్యుయేషన్ ఎగ్జామ్. గవర్నమెంట్ జాబ్స్ కి చాలా కన్సిడరేషన్ తగ్గిపోతుంది. గ్రాడ్యుయేషన్ చాలా మంది అడర్ వాళ్ళు కూడా పీజీ కంప్లీట్ చేస్తారు. ఎడ్యుకేషన్ పడుతుంది, అయిపోయిన తర్వాత వచ్చి. బట్ ఎప్పుడైనా కానీ రాయాలి, ఎగ్జామ్లో అడుగుతారు. బ్యాక్గ్రౌండ్ చెక్ లో కూడా తెలుస్తాయి రాకపోయినా, పడతాయి బైక్ చలాన్స్, డ్రంక్ అండ్ డ్రైవింగ్స్. చాలా మంది క్రైమ్స్ కూడా ఎట్లా అంటే 2 రకాలు ఉంటాయి. ఒకటేమో క్రైమ్స్ ఆఫ్ మోరల్ టర్పిట్యూడ్ అని. మోరల్ టర్పిట్యూడ్ అని అంటే నీ మొరాలిటీ కూడా కొన్ని చేసినే ఉంటాయి. దాటినావు, బైక్ చలాన్ పడ్డావు, it is a passive euthanasia కిందకి వస్తుంది. Comes under passive euthanasia. That's why I'm asking you to study. There are 2 types. Passive euthanasia. Euthanasia means mercy killing. Person will not survive. Person will not survive. Okay, survive. Cover a chances. Then you are saying the ventilator and any common passive euthanasia. Passive euthanasia is giving something not the chance of no right to die. That's why suicide attempt is still not 9. Attempt to suicide and criminal punishments దగ్గర అంటున్నాను ఉందా అంటే, ఎందుకంటే రైట్ టు డై లేదు, లైఫ్ తీసుకునే హక్కు. లాస్ మిస్యూజ్ అవుతుంది ఇప్పుడు కూడా చాలా అవుతుంది చాలా కదా. ఇప్పుడు ఎందుకు ప్రజా సంఘాలు వీళ్ళందరూ కోర్ట్స్ ఇవన్నీ మిస్యూజ్ ఏమీ జరగకపోతే అసలు ప్రాబ్లమే లేదు కదా, హ్యాపీగా సాఫీగా ఉంటుంది. యాక్చువల్లీ అపోజిషన్ పార్టీస్ డిసెంటింగ్ అగేన్స్ట్ గవర్నమెంట్ అసలు ఇవన్నీ పెడుతుంటారు, యూఏపీఏ పీడీ లాస్ అని అంటారు, పీడీ లాస్ పెడుతుంటారు. ఒక పర్పస్ కోసం పెడితే అవి మిస్యూజ్ అవుతాయి. సెడిషన్ లా, పీడీ, ఏపీఏ, ఎన్ఎస్ఏ మిస్యూజ్ అవుతుంటాయి. అన్ఫార్చునేట్ కోర్టులో ప్రూవ్ చేసుకోవాలి. మూవీ వాడు క్లియర్ గా ఏమని ఇస్తాడంటే దిస్ ఇస్ ఫర్ ఎంటర్టైన్మెంట్ పర్పస్, రియాలిటీ కాదని చెప్పి. మూవీలో మర్డర్ అవుతుంది అంటే చేయమని కాదు, అది మూవీలో మర్డర్ చూపిస్తాడు, బాంబ్ బ్లాస్ట్ చూపిస్తాడు, చూపి ఎక్కువ వైలెన్స్ చేస్తే చూపి అది వాడు క్లియర్లీ ఫిక్షనల్ అని చెప్తాడు. ఫిక్షన్ అని చెప్పి ఫిక్షన్ అని చెప్పినప్పుడు నువ్వు ఫిక్షన్ లా చూడాలి, కానీ నువ్వు అది అని అఫెన్స్ అని చెప్పి సెన్సిబిలిటీ ప్రకారం ఉండాలి అని అనట్లేదు. ఇంట్లో మర్డర్ చేస్తే నేను చేసిన అన్నట్టు కాదు, ఇంట్లో ఇటు వెళ్తే వెళ్ళినాక. కానీ నువ్వు ఒక హీరోనే అట్లాంటి పనులు చేసేటప్పుడు యూత్ కూడా వాళ్ళకి అదే అర్థం, అట్లా వచ్చా అట్లా మైల్ వెనకాల పోతే అట్లా పడతారేమో, ఆ థింకింగ్ వస్తుంది. దానివల్ల అఫెన్సెస్ కమిట్ అవుతాయి. దట్ ఈస్ వాట్ తిడుతున్నారు కొంతమంది మూవీస్ ని, క్రిటిసిజం వస్తుంది, కానీ అట్లాంటి వాటి బ్యాన్ చేయలేదు. ఫిక్షన్ అని చెప్తున్నాడు, రియాలిటీ అని ఏం చెప్తున్నాడు. మెచ్యూరిటీ లైఫ్ అంతా కెరియర్ అంతా జడగొట్టుకుంటుంది. అందుకనే మూవీస్ కి ఇంకా సెన్సార్ సర్టిఫికేట్. ఈ రోజుల్లో ఓటీటీ అని వచ్చినాక మూవీస్ ఇంకా చాలా ఇన్ఫ్లుయెన్స్ ఉంటుంది, అందుకనే మీకు సెన్సార్ సర్టిఫికేట్. లేకపోతే ఎందుకు సర్టిఫికేట్ అంటే okay, so when you are studying, so the task given to you with respect to right to die, when you study about right to die, study about whether, which means that, you know, do you have a right to commit suicide? Okay, so that also you see. And there is also assisted suicide on top, which is what we call as mercy killing or euthanasia on top. So study about that also. Euthanasia. Euthanasia means mercy killing. ఒక రకంగా అసిస్టెడ్ సూసైడ్. సో అలా చేయొచ్చా? ఈజ్ ఇట్ అలౌడ్? That I want you to explore those areas. So that is a homework. Please go and spend time. Don't come like, as sir told something, what is there and all. Don't be like that. Please, I give only some homework I give. So at least that much you have to show interest and go and find out. Only when you explore and all, you will learn deeper. Okay. So read about that euthanasia as well. Mercy killing. Is it allowed in India? Okay. Recently, one software engineer in Bangalore, 1 year ago, what he did was, he was suffering from some illness. So he wanted to do euthanasia by taking some injection and all. In India, it is not lawful. Okay. So that's why he wanted to fly to some other country where euthanasia is illegal. But again, his friend told to police, they stopped him at the airport. Because in India, you know, anyway, I'm revealing it, there is no right to die. Okay, you don't have a right to die in India. Okay. How that is, why that is and all, you study that. Okay. So study about euthanasia as well. And the other is, when I tell you that, when I tell, you know, regarding the movies and all, see, movies is an act of fiction. So in movie, the hero murders also, he beats also, he slaps. Those are, for that we can't file cases against the movie producer or director. That is an act of fiction. Movie lo chupichinanta matrana, I am only talking about the moral aspects. I'm not speaking whether it is unlawful. It is legal. We means creativity, fiction. Somebody is writing a novel. horror novel they are writing, crime thriller they are writing, or they are writing they are doing a movie, or it's a fiction. Showing that is not per se illegal as such. The only thing I said that, we are stalking behind girls and all that. When a hero or a prime character does that, it has a negative influence on the youth. It is not as if all youth will do that. Not everyone will do that. Hero went behind girl, I can also not. But there will be some immature mind. Some minds will be immature. They will also be like you're saying, they are seeing animal movie, they will also start behaving animal. Seeing Arjun Reddy movie, they will also behave like Arjun Reddy. They'll keep slapping and all, ferocious. If you do such things, outside, you won't be treated as a hero. You'll be treated as a pakka criminal. Don't. So all the heroics will not be tolerated. The thing they show in movies, what they do is they show it as a human-centric approach చూపిస్తారు. అంటే from the lens of hero they show that. So what everything he does is right type lo they show it. But in reality, in society, everybody is a hero. All of you at some point, in my life, I am hero, I am heroine, you will be thinking. So nobody is less. But from a movie, they show as if, heroes world type lo చూపిస్తుంటారు. In a real day life, everybody is there. And don't think you are the most powerful. Other people are there powerful, and the system is more powerful than you. So if you do hero-like antics, okay, then you will be put in your place by the law. So that is what I'm saying. So some influence is there on some people where they go and do such antics and all that. Because of that, they get into trouble. So that's what I'm telling. Per se, what the movie makers are doing is not illegal as such. Any act of fiction, ante, they clearly says. So these characters and all you are saying, right? These characters do not resemble anyone living or dead, and all that disclaimer they are giving you. Okay. Anyways, next let us see right to privacy case. Right to privacy is K.S. Puttaswamy versus Union of India case. K.S. Puttaswamy versus Union of India. There is a case in which Supreme Court held that right to privacy is also a fundamental right under Article 21. Because it comes under life and personal liberty. So life, personal liberty kindiki vastundi. Your right to privacy. So this question came up. Why it led to this case anante in 2017 and all the judgment is given. So why it led to this means before this, a little before this, what happened was your Aadhaar started. So your Aadhaar cards and all that process has started taking your biometric details. All of you have given your biometric details, iris scan, fingerprints and all that. So, okay, you have taken saying that, there will be a unique identity. That is a UIDAI, unique identity, you will get cards for residents. Okay, people were giving. Some people said, why we should give? Is it compulsory? At that time, they said that, so it is not compulsory. Right now also, Aadhaar is not mandatory, by the way. Aadhaar is not mandatory. So, Aadhaar and all, some people started asking why you are taking our biometric details. What if they are misused? You're taking my fingerprints. What if you misuse? Your fingerprints are all in the database. What, like, let us say I have a grudge against Neeraj. Neeraj's fingerprints are there in the database. If I take nicely those fingerprints, put them and implant them in a scene of offense. For a murder jarigindi and all, some crime is there. These fingerprints are implanted there. Then may be misused, my biometric details may be misused, why I should give to the government? Itlanti questions started coming. So government came into a fix. Government said that, see, Aadhaar per se is not mandatory and all, or is it mandatory and all, questions came like that. So from the Aadhaar case, whether Aadhaar is mandatory or not, first we have to check whether right to privacy is there, right? Private details, these are your privacy, your biometric details, your iris scan, your face, your details, these are all very private details. So your privacy, is it a fundamental right or not? First we should ask that question before checking whether Aadhaar is mandatory or not. Aadhaar mandatory or not, chuddaniki first another question we have to answer, whether right to privacy is a fundamental right or not. That should be answered first. Does it come under fundamental right or not? So that became Puttaswamy versus Union of India. In that the question came, constitutional question. Whenever a constitutional question comes, whether it is fundamental right or not, whether it comes under article or not, itla constitutional interpretation, every time at least 5 judges, 5 or more judges, constitution bench form చేస్తారు. Constitution bench is formed in odd numbers by the Supreme Court. Supreme Court is a final interpreter of Constitution. Final interpretation only Supreme Court. So Supreme Court, it forms when Constitution bench to determine such questions. It can be 5, 7, 11, 13, like that, it can be odd numbers. So it also formed one Constitution bench to decide this case, to decide whether privacy comes under fundamental right or not. So in that case, so it has studied, what is privacy, what comes under privacy, and all this is there here. We will see. Earlier, there were cases called Kharak Singh case, and also your earlier MP Sharma case. Long ago in 1954 and 1961, here Supreme Court had somehow given an interpretation that privacy is not a fundamental right, like that it has given interpretation. But now, when this Puttaswamy judgment and all, at that time, Constitution bench it deeply studied whether privacy comes under Article 21 or not. And after studying it, unanimous decision it has given. Unanimous means all the judges said, not even one minority got a judgment. All the judges unanimously, 9 judges unde, all the 9-0. All the judges said right to privacy comes under Article 21. It is a fundamental right. It comes under life and liberty and Jappar. So it ruled that right to privacy is an intrinsic part of right to life and liberty. That is Article 21. Okay, what is privacy means? Privacy includes personal intimacies, sanctity of family life. It may include marriage, procreation means children, home and sexual orientation. These all comes under privacy. What you do within your house, in your own personal time, how much time you sleep. Do you want state to interfere? Do you want government to interfere daily? Hey, what is the time to get up and all? Government should come and check you. Hey, why you are eating daily idli and all? They want to check like that. Or who you want to marry and all? Do you want like them to check? No, government should not be bothered. States should be limited. Remember, constitutionalism means limited government. So government should limit in its role. It should not enter into your privacy unless required. Sometimes it may be required. Like, you have done a crime and sat in your home, police will come and catch you, even if you are in your house. If you have not done a crime and you are in your house, police should not come into your house and ask, hey, what you are watching, man? Okay, open your browser history. Like that, you want police to come and do that? No. Okay, what is your privacy? Which channel you are watching? Okay, why you are watching ETV? Watch Sakshi. Why are you watching Sakshi? Watch ETV. Like that, you want government want to control your habits, your food habits. These are all your privacy. Can government come and ask couples, hey, how many children? 1 kid. Hey, go for 3 kids. Now why only 1 kid? Like that, can the government come and force them? No. So it is procreation. Their procreation, their family life, their marriage, who they want to marry, how they want to marry, their life, their personal intimacy, who you want to be friends with. They can't become like the Ma-Baap. Government cannot become like the Ma-Baap and all. They cannot be. Sometimes parents do this, right? Hey, why are you friends with that girl? Not that girl. Be friends with this girl and all. You're not children, right? Government will interfere and tell you, who to be friends with, who to talk with, who not to talk with and all. Government should, this is all your private matter. Even to the extent of, it also said your home what you do. And even the sexual orientation also it said. So people have various sexual orientations. These LGBT rights and okay, lesbian, gay, bisexual, so transgender, these LGBT community rights. So wala orientation, because that's also nice. So it is also a privacy. State should not interfere. So like that, these are all coming under privacy. Privacy also means right to be left alone. You want to be left alone. You don't want to be interfered with. You want to live your life. Government should not come and tell, hey, why are you studying for civil services? Why don't you study, some cat ki prepare ho and government anala? No. So that is what, these all are your privacy, which means a person should have individual agency, autonomy you should have over your life. The control of your life should be in your hands. You should not give that control to the government. So that's what, it is a right to be left alone. It safeguards individual autonomy. Autonomy means you have your agency, you have your power over yourself, like independence. Okay, and recognizes ability to control vital aspects of one's life. నీ లైఫ్ మీద కంట్రోల్ యూ షుడ్ హ్యావ్. సో ప్రైవసీ గివ్స్ దట్. Okay, so however, privacy is also not absolute right. Privacy is not absolute right. It is subject to based on legality, need and proportion అని అంటాం. అంటే let us say you are saying in my home what I do is my privacy. Yes, but in your home if you are regularly you are beating your wife, committing a crime, then police will come inside your house. Okay? If you are mistreating your children or doing some offense, then police will enter. In your homes you are doing cyber stalking, harassing some women, then police will come inside your house also. It depends on the legality, need, but there may be invasion. Otherwise they should not invade. Okay, so normally your phone should not be checked by police, but if they have a doubt that you have committed a crime, then they may take your phone or your laptop. So like that, yes, it is not an absolute right based on legality. So anything law is there, legality is there, any need is there, suspicion is there that you did crime, or proportion, how much it is necessary, that much they can invade your privacy. Otherwise you have privacy. So finally, right to privacy is a fundamental right. Like that, all these judges have given a judgment. Okay, it comes under Article 21 of your constitution. And many questions were asked regarding right to privacy. Again and again they were asked. Right to privacy is protected under which article of the constitution? See. So after giving that judgment, immediately what happened? We have to answer. The earlier question was whether Aadhaar is compulsory or not. So Supreme Court said that Aadhaar is, you can make mandatory only for government services. You are obtaining any government services, then Aadhaar may be made mandatory. Government benefits you are getting, government services you are getting, then Aadhaar may be compulsory. You are going to register your vehicle, they may ask your Aadhaar. Let us say you are getting a subsidy, you are getting some ration, okay, or you are getting some any other scholarship you are getting, they may ask your Aadhaar. Because akkada government em cheppindante Supreme Court lo, sir, the purpose of Aadhaar is to segregate. We have to see whether any fake beneficiaries should not be there. Okay, they are creating these fake beneficiaries, they are creating false beneficiaries. Evado leni pulaya elaya they are writing, and they are giving ration to him and all, and they are selling it off. That's why we want to weed out these false beneficiaries, fake beneficiaries. That's why Aadhaar number is there, should be there, like that. They said, okay, if you want to get government benefits, government salary you want to get, benefits you want to get, anything from the government services you are getting, then Aadhaar is okay. Otherwise Aadhaar is not mandatory, it said. So today, if you don't want any government benefit, if you don't want any government service, then if you don't have Aadhaar also, it is not a crime. Some people, they didn't take Aadhaar at all. Up to now, they have never taken Aadhaar. Because it is not mandatory. And for private things and all, it is not must that only Aadhaar should be shown. Suppose if you want to fly somewhere, if you want to go to country, you can show PAN card, you can show other cards also, voter ID you can show. Those IDs also chalega. Okay, for private services, if they ask Aadhaar, let us say you want a SIM card, generally they are saying Aadhaar de do. But if you say, I didn't take Aadhaar, aise cases are means take voter ID. If you show voter ID also, he has to give you SIM card. Because it's a private thing, it is not a government service. Giving a SIM card is not a government service. So for SIM card and all, even private also should be accepted. Show voter ID also, he should give you SIM card. But the problem is they are saying, sir, Aadhaar is easy, sir. You put finger like this on that, easy SIM card will give. Like that, they are saying easy, but it is not mandatory. Remember, Aadhaar is not mandatory, Supreme Court said, except government benefits, government services. If you are a beneficiary only, you will require, Aadhaar is mandatory. That judgment also came. So next, because of right to privacy judgment రావడం వల్ల in privacy, if you clearly observe, Supreme Court also said that what all comes under privacy means, it said sexual orientation also. Sexual orientation also comes under privacy. So now LGBT community, for a long time they have been fighting for their rights. So LGBT, some people say LGBTQ and what a Q plus and under all that, lesbian, gay, bisexual, transgender, okay, and queer, intersexual, and so on and so plus. So all that community, especially homosexuality, especially lesbian and gay communities and bisexual community. They were subject to discrimination for a long time. They were treated as criminals because British in IPC long ago, they have put one IPC section called as section 377. This is important. You now this section you must remember IPC. Not everything in IPC I told you is not necessarily remember unless in current affairs, but this section had led to that judgment. There is a section in IPC 377 which we call as unnatural offenses and antam. Unnatural offenses. So unnatural sex. And see, we are all adults and all. Tomorrow you are in police, you are in administration. See, though whoever are in administration, whoever are in police, especially in police, whoever are in courts, advocates, whoever are in doctors' profession, surgeons, you have to deal things which other people may not have to deal with. You may have to deal with crimes, murder, rape, violence. You will see things which other people may not see. So as a subject you must study. When things come also, you should not say why Sari is telling these things, what is happening and all. You should think in an objective manner. Like an adult you must think. Okay, certain things are there in society, you will have to learn them as objectively. Only then you will know what is law is telling, what is there and all. You'll have to learn. So unnatural offenses in this IPC it is put. Britishers and all, they have put in 1 year, 10 years later of 1860, 1870, they have included this. Saying that, if there is any, what they treated as unnatural is homosexuality also, they said is unnatural. So a man with a man or a woman with a woman, this is unnatural because the thinking is that, generally a union, okay, a sexual intercourse and all, it's only like you should only happen with a man and woman. Like that was the thinking of Britishers. Okay, so anything else is unnatural, they felt. How can a man and a man be having a sexual intercourse? Like that they had thought. How can a woman and woman be? So that's why lesbians, gays and all, they were treated like criminals. Moreover, and also what else is there in 377? Even unnatural, they put that even with animals, anything with animals also, that is also treated as unnatural. So now, but in a Supreme Court judgment, you are saying that sexual orientation, what your orientation is also your privacy. What does state have to do with it? State should not interfere it. So that's why these people have been fighting for their rights, saying that please decriminalize 377. 377 ni unnatural antunaga adi kotteyandi against homosexuality. Please strike it down. Like that, LGBT community have been fighting. They have fought, they have formed one foundation called Naz Foundation. This Naz Foundation has fought, in this case in Delhi. So in Naz Foundation, so they have fought in Delhi High Court this case. Delhi High Court, it said that, yeah, this is correct, only they decriminalized. But when it went to Supreme Court, at that time, Supreme Court said that, but law is there, now Parliament, it is still there. Law is made by Parliament and all. How can we do like that? At that time, right to privacy judgment didn't come. But once right to privacy judgment came, it was challenged in a case called as Navtej Singh Johar versus Union of India. So right to privacy judgment given in Puttaswamy versus Union of India, KS Puttaswamy versus Union of India, that judgment, it gave a boost to this LGBT community, saying that it is our privacy, na? You told sexual orientation is our privacy. Then why you are treating us like criminals? So they challenged 377. So remember what is Article 13 telling? Laws inconsistent with fundamental rights. To that extent of inconsistent, they will become void. So this is judicial, means you are asking for judicial review. So they challenged 377. 377 is also IPC mein, 377 is also a law. This is also a law. So this law is being challenged. Please make it void, they are asking. Because it is against fundamental right. So Supreme Court had to check against fundamental rights against this LGBTQ community. So the Naz Foundation, they started their fight. But let us see what is 377. 377 unnatural offenses. Whoever voluntarily has carnal intercourse against the order of nature with any man, woman or animal, they shall be punished with life imprisonment or with imprisonment which may extend to 10 years and also fine. Okay. So any penetration is sufficient to constitute carnal, that is sexual intercourse in this section. Like that, this British have brought this particular section, they have brought. So, but why we should be criminal, we should not be criminal, like that they have filed. After Puttaswamy judgment, this Navtej Singh Johar and we say Akkai and all these people have filed in the Supreme Court saying that we should not be treated criminals. 377 ko kharij kar do. You have to, in fact, decriminalize it, like that they said. So Supreme Court finally in this it formed a constitution bench again, because whether it is constitutional or unconstitutional, like that they had to check. So this these judges unanimously they gave a verdict and they said that yes, section 377 law, that part which is homosexuality, you are criminalizing, it is wrong, it should be decriminalized. So finally what they have done is they have decriminalized homosexuality, decriminalized they have done. So they said that section 377 may it is irrational, indefensible, arbitrary, they said. Arbitrariness under, which article? 14 is being violated, equality is being violated. And Justice D.Y. Chandrachud, now he is the CJI. At that time, he was just the judge, one judge. Now he became Chief Justice. It is difficult to do so long in history we have done wrong. So entire history we can't do, but now at least we can do right. So like that, now we can set the course for future. That's why this is more than decriminalize homosexuality. We should let those people live with the dignity. Because see, Article 21 means life with the dignity. But now on the other hand, you are not giving them dignity. So Article 21 we are bringing. And Justice Rohinton Fali Nariman, persons who are homosexual, they have a fundamental right to live with dignity. Again, Article 21. So you should, dignity is mentioned in the preamble of the Constitution also, preamble also. So we should assure the cardinal constitutional value of fraternity also. Remember fraternity. Okay, we said assuring the dignity of the individual. We said that. So then these are all important. Then you have to treat with fraternity. How can you treat them like criminals? So see Article 21 violation also. And Justice Indu Malhotra, she also said history owes an apology to the members of this community and their families. So this entire, all the families, we have subjected them to shame by making them criminals, look like criminals. And it is not a disease. See, many people have a wrong notion that homosexuality is a disease. It is not a disease. It is just nature only. In nature, some people are wired like that in the brain. They have such kind of orientation. And when studies are done, Supreme Court, it went into depth when studying this issue. And Supreme Court, what it found out was, it is not only Homo sapiens in which there are some homosexuality tendencies. Even in other species also there are homosexual tendencies. Even in birds species also homosexuality, some tendencies are there. In some animals also homosexuality tendencies are there. Like that, many species they have studied. So the botanical studies and all these zoological studies, biological studies, they found out that in other species also of animals also, we are finding tendencies of homosexuality. Human beings also come under animal kingdom. You see, biology wise, you see, we come under animalia kingdom. Because we are vertebrates and all, chordata and all, androke vachestam. But anyway, so we animals, so if species lo konta orientation unte, it is in nature, right? In nature, it is there. Some people are like that. You have to accept it. If you don't like it also, you should be calm. You should not put criminals and you should send them to life imprisonment 10 years. Hey, how can you do like that? How can it should only be man and woman? So that kind of thinking need not be there. You can't criminalize them. Let them live their life. You can't make them criminals. So like that we have to treat. But all these years we have put their families and members to shame. So everyone owes an apology to them. We all should be sorry as a society also. Supreme Court is only telling that, we all owe an apology to them. Our entire history should say sorry to this community for making them look like criminals. Okay. So for delay in providing the redressal for the ignominy. Ignominy is shame. And ostracism. Ostracism means velivedam. We have expelled. Many times, these people are not able to tell that they are homosexuals. Many times they don't tell that they know because of fear of society and shame in society. And some movies are also, they are making fun of, hey, you are gay, you are lesbian. Like, they are making fun and looking as if it is a funny creature. It's that is how they are. It's a natural thing they are. Some people may be there, minuscule people, but it is how they are. So you can't completely treat it like a kind of a disease and all. So, but the moment somebody says they are homosexual, immediately parents' reaction is violent. Parents, see, when the person comes to adolescence and starting to have secondary sexual characters, now he realizes his sexual orientation. Maybe if the boy says, I'm only attracted to boys, or if the girl says, I'm only attracted to girls, like that, if they tell to the parents, it is horrible for parents. Parents react like that. Hey, no, that's why we told, don't watch English movies and all that. They are, it is not to do with English movies or any other movies. It's not about that. The orientation is like that. They have to understand that. But most parents in Indian society, there is no such understanding, mostly. So that's why they are saying they'll take them to a doctor. Doctor knows science. Doctor says it is a natural thing. It's a natural. We can't do anything. It is no matter, there is no treatment. Disease के लिए treatment. This is not a disease. Sir, mental का कुछ होगा no? Nothing mental. It is natural. Still parents are not accepting. They're saying, no, I will take to that Baba, this Baba, Ramdev Baba and all. Ramdev Baba once said, I have a cure. Ramdev Baba said for everything he has cure. For corona also I said I have a cure. There, first of all, it should be a disease. Then only there is a cure. There is no cure for this. Okay? Because it is natural. But society is finding hard to accept that this is natural. This is the problem even today in society. At least, but law, it should give them rights. So that's why what it has done is the decriminalized homosexuality. So section 377 today, what happened means to 377? 377 May, this man, woman is gone. Only animal and all, it is still punishable. That is an unnatural offense. Why would somebody, have with animal and all? That is unnatural, but this part is decriminalized. Man and woman. So homosexuality got decriminalized because of this judgment. And in this entire judgment, all the 5-0 verdict came. And what it said that rights of individual, it said that a person is not even able to express. Whereas your Article 19, you said that, freedom of expression should be there. The person may like a man may like another man, but, denial of self-expression and all is there. So that's why it said that, individual liberty will get more preference than community preference. Society may see it as a crime, but law should give preference to the individual right in this case, it said. So denial of self-expression is like death, it said. You should give, you should not deny self. And sexual autonomy is important pillar and it's an important facet of liberty, it said. Dignity, it mentioned. So it comes under, and you said that in Article 15, do you remember? In Article 15, we said, no person shall be discriminated on the grounds of race, religion, sex also. Remember, it said that sex doesn't mean only gender, it also means orientation also. Just because somebody is a lesbian, gay, you can't discriminate them. Like that also it said. So it will be violative of 15 also. Having 377. So right now what is happening? 377 May, that man, woman part, okay, that homosexuality part, it is getting conflicting with your fundamental rights. Which fundamental rights? 14 it is violating, 19 it is violating, 15 it is violating, most importantly, 21 it is violating. Life with dignity it is violating. So what is Article 13 telling? If such law is there which is violating fundamental rights, that should become, to that extent it should become void. Doctrine of eclipse. Okay, because it is pre-constitutional, it's coming. So that eclipse, that should be eclipsed. That part is decriminalized now. So, and Supreme Court said it is not a mental illness. It is not at all a mental illness. So Mental Health Care Act also is telling, there is an act also, studies, doctors, all of them said that this is not mental health problem. It is a natural, it is in nature. So all this is a stigma is faced by many LGBT community people, that should be removed. So sexual orientation, it implicates negative and positive implications on the state. It not only requires not to discriminate, but also you should recognize their rights. Just let them recognize their rights. You should not criminalize them, it is saying. And it is not against the order of nature. See, entire 377 itself, the title itself is unnatural offenses. The title itself is unnatural offense. Unnatural means not in nature. But what we found in studies we are finding that it is not unnatural. So 1500 species lo undanta. Other than human beings, in 1500 species, animals, birds and all those species, homosexuality is there, it seems. Then it is in nature, right? How can you say it is unnatural? That's why you should not punish like that. It is not against nature, it said. So like that, it has rejected this notion. And more importantly, towards the end, it has said, see, society today it will tell something, tomorrow it will tell another thing. The same society, if you go some 100 years ago, it said, jump in fire, it told to the women. Okay. Sati, it said. Society had allowed dowry. Sati had, society may allow child marriage. Society may tell widow cannot remarry. Okay. Society may say women should be only in the kitchen. Society tells 100 things. But only the entire society, if you follow, then we won't progress. What is more important, it said that when society may have some kind of morality, morals, society will tell some morals and values. Constitution says some morals and values. So Supreme Court said constitutional morals are more important than societal morals. That's why in India, constitution is supreme. So it said that constitutional morality, no, it is more important than what you are saying about societal morality. It triumphs over societal morality. So when you compare both, constitution ke importance is. Constitution tells this is law, you have to follow that. Not, society will tell 100 things. Like I told, Kap Panchayats, they told women no mobile phones, women should not wear jeans, do this, that. These all things we cannot follow just because society is telling. Constitutional morality is more important. And our constitution is transformative. Means it keeps changing. It is dynamic. Depending on the situations, we are changing. Once we thought that LGBT community, it is criminal. But now latest studies came, 1500 species law, how it is unnatural. We are realizing it is not mental health problem also. Then you can't say that it is criminal. That's why transformative constitutionalism untundi manaki. Means constitution is a dynamic document. We are progressively realizing various rights. At one point of time, we thought that is not a right. Now we are giving them rights. Yes, homosexuals also, not criminals. They can do what they want. Because it is privacy also, right to privacy. What they do in their privacy, so long as it is consensual adult. Again, see, it should not be minor. It should be based on consent. Avi lekapothe rape avutundi. There should be consent. It should be an adult. Then it is heterogeneous or homo. So it still doesn't matter. It may be heterosexual, it may be homosexual. State should not interfere. If it is a minor, state will interfere. ఎందుకంటే minor cannot give consent. Minor is not capable of giving consent. అర్థం అవ్వదు అసలు ఏంటి వాట్ ఇట్ ఈస్ అండ్ ఆల్. సో దట్ ఈస్ క్రైమ్. మీకు అప్పుడు పాక్సో కింద కూడా బుక్ అవుతారు. ఆల్సో రేప్ కింద కూడా బుక్ అవుతారు. ఆర్ consent is not there, then it is also rape. But if it is an adult and also not a minor, means major, then we should, then whether it is a heterosexual or homosexual, state should not interfere. So that's why by decriminalizing it, it said that progressively manamu rights istunnamu. Once upon a time we didn't think of transgenders. Now transgenders are also having rights. Lesbian, bisexuals are also getting rights. Okay, Viklang, Divyang, we are saying they are also having rights. That's why, progressively we are realizing rights. Earlier, if a Divyang is there and all, we didn't care. Now, if a Divyang is there, separate lifts. You are seeing, right? Separate lifts, separate toilets are there in railway stations, airports. Ramps are being built in your metro stations. Why? Because, a person in wheelchair also should be able to go. Okay, in ATMs everywhere and all, you are seeing those are blind also, just by touch. Tactile also, they will be able to tell. Or sound comes. Earphones petkoni vini kuda they can operate. Why we are doing all this? Because everyone has rights. You may be, a person may be physically disabled, still should be having rights. We are progressively, we are realizing various rights. Means our constitution is also slowly progressing. Means we are moving forward. So that's why it is not a rigid it is not like it will sit here only. It is a dynamic document. It moves along with the society. Sometimes before the society reaches also, it will go. And it will give importance to individual rights. So constitutional morality is not confined to literal text of the constitution. Rather, it must give pluralistic and inclusive society. Our society should be inclusive. We are saying fraternity and all that. So all people we should treat like Indians as a family and all. You have to include all the sections. Be it even lesbian, bisexual, gay also. You should treat like that. Like that it said in this. Okay. And also it brought in this doctrine of non-retrogression. It said that it should be progression. Means you should go progressively. Non-retrogression means you should not go backward, you should go forward. So which means that Let us say now Navtej Singh Johar. So Navtej Singh Johar case, now you have given right to this, in a way you have given right, you have decriminalized homosexuals, means they are not criminals. Once you have given a right, that right cannot be taken back. Suppose a right is given, you can't take back right. This is the concept generally we say. Generally rights ఉండొచ్చు ఉండకపోవచ్చు, but once you told that there is a right, you can't take back that right. Tomorrow parliament cannot make a law saying that again we will criminalize homosexuality. చేయకూడదు. Can parliament make a law saying that no, again we are bringing back 377 homosexuals, we'll keep and all in that? No. Supreme Court again it will strike it down, because that is a doctrine of non-retrogression. Non-retrogression ante you should not go back. Once a right is recognized, it cannot be reversed. So we are giving this right over, whether society likes it or not. Today also society won't like it. Many families and all, they won't like homosexuals, no, and all unthinkable like that they do. But Supreme Court said, no, you have to go forward. That's all. We are giving the right. See, what is, maybe not now, but after 20 years, 30 years, there will be recognition in society also. Society also will see. So like that, it emphasized unbridgeable divide between moral values of society and moral values of constitution. Constitution gani 377 unbridgeable divide undi. That's why we said 377 is made void. Not entire 377, partially. Partially it is made void. Still that animal and all that is still there. This part is made void. So this is an important judgment, landmark judgment antam. Important judgments annindi landmark case antam. Navtej Singh Johar case is also like that. So today you studied many important judgments came in this class. One is A.K. Gopalan case, but that was reversed by Maneka Gandhi case. This is a landmark judgment. We have studied K.S. Puttaswamy case. Okay, right to privacy. Okay, and then we have studied Navtej Singh Johar case. This is decriminalized 377. Homosexuality got decriminalized. These are very, very important judgments. Can be asked in prelims, can be asked in interview, anywhere it can be asked. So you should quote these judgments. And 377, you should say which judgment also. Navtej Singh Johar judgment, Maneka Gandhi case, due process of law. Like that, you should be able to quote these judgments. Okay, so that is about your Article 21. No, that is not granted as of now. Yeah, so that case also in the Supreme Court, it was heard, and recently it was heard. But marriage is only a sanctity. Sanctity is there, marriage based. So marriage rights are not there, it Supreme Court said. Because as of now, marriage laws are made, all the laws are made with the assumption that it is between a man and woman. So because of marriage only, you will have inheritance, ivanni untai. Whereas here, procreation will not happen, right? In homosexuality, procreation is not happening. So based on certain things and based on the precincts of concept of marriage, kindiki radu ani cheppin. These people, they are going outside the country and marrying and coming if they want. In India, marriage rights and all are not there, because it creates other problems. It creates problems under society kaadu. Right to marry who you want is a fundamental right. See, right now, if two lesbians or if they go and marry if the priest is doing marriage, then no problem for us. We won't arrest them. But we won't give the recognition of marriage. Marriage certificate they won't give. If you marry, we won't arrest you. But certificate we won't give you. You can't go and register that marriage. Because marriage toti emostayi ante other rights ostayi. Marriage right, conjugal rights ostayi. You get inheritance rights. Children get inheritance rights. Iyanni ostayi. And divorce concept ivanni ostayi. All those laws are made thinking it is between man and woman. So all of them will have to be changed. So in a detailed judgment, it said, or maybe tomorrow we shall discuss that judgment also. Yeah, they were released. They were released. So those who are already, so whenever the benefit of change of law is given to the detainees or who are under trials or prisoners, వాళ్ళందరికి ఇస్తారు. Very few were booked. Very few people are actually arrested. And any law, if the law is changed, the benefit is given. Why? Because we said that don't give a penalty greater than అన్నాం, కానీ lesser కి change చేసినప్పుడు you can give the benefit. No, we discussed that, right? No ex post facto law. If I is made into 2 years, you can give the benefit. You can give the benefit. So that was also one judgment came regarding that. You can give the benefit. Lesser చేస్తే ఇవ్వచ్చు. Greater penalty వేయకూడదు. Okay. There is a regarding this also. Recently, there is a good Malayalam film is there. Kadal the Core ani. So it's a beautiful movie made on how society did not accept and what happens later and all. There's a very good Malayali film is there. I think it's there on Prime or something. So if you want, you can watch it. You'll get an idea about the issue in society regarding this homosexuality. Yes, let's meet tomorrow's class.
Also, the district magistrate. Then what are the cases he did?